I want to mention two criminal of this of the year 2014 cases, wherein custody more than 30 years.
By your Lordship, say GLS matter remanded by the Honorable Supreme Court. Your Lordship had the matter extensively and adjourned the matter to 24th February on the prayer of the government to produce the record as a last chance. Thereafter, it has been.
Let's criminal offense for bail.
Rather, residential matter
Land action recommended.
Supplemental list, item number 1.
May I please, madam? Just sitting for the first time with regard to this matter, my lord. The brief outline of the facts of the case is that Transvaal project, there are 339 families who have been displaced, for which an amount of 4 crores and all has been deposited with the collector as per annex page 39. The collector is awaiting instruction from the government to disburse the amount. And your lordship, for that reason, on 30th January, directed the state to obtain instruction from the secretary. Thereafter, the land acquisition on the basis of piece of paper when are submitted to your lordship without giving a copy to me, the land acquisition officer directed to make substance inquiry. When the collector is awaiting the instruction.
Wait.
All 339 families, page 41, 42, madam. Already been identified.
Last occasion you
Yes.
time to a certain.
Yes, these 12 petitioners are within the displaced family of 339 families. That is the instruction which we have received. The compensation is yet to be sanctioned. Your lordship directed on the last on
26/3/2020. What instruction you have received, please pass it.
Your lordship. These petitioner may represent the 339 families for which a petition order 1 rule 8 has been filed.
Please wait.
And they are not giving a copy of whatever they are submitting to your lordship. How is then flipping? Not disputed, page 41, 42.
Please wait. I'm to say that 12 petitioners who have filed the writ petition are in the list of 339 families for whom compensation is yet to be sanctioned. That is your instruction. So, what is your representation you submitted?
And it's a 8 series by representation submitted. This is the amount has been deposited, my lord, since 2014, page 39. Collector is awaiting the instruction from the state to disburse the amount. How can the land acquisition officer who is way below the collector disburse the amount without the collector getting the sanction from the government, my lord? For which your lordship 30th January directed the state to give the instruction. 2014, the amount is lying in deposit. And these 339 families, page 32, my lord, including the petitioner, are there. And these petitioners have representing the 339 families filed the writ application. So they cannot be excluded from 339 families and paid the amount.
Nobody is excluding you. The instruction is that.
Along with the 339 families, my lord. This is page 42, my lord. Your lordship may see
Your name is in the list of 339 families for whom the compensation is yet to be sanctioned.
Well, page 42, my lord, your lordship may just see the 339 families are there, identified.
Yeah. You 12 are also included.
Yes, my lord.
So what is the problem now?
Problem is not they are not disbursing because of the awaiting instruction from the state government. Page 39. The collector has asked for the instruction from the state government to disburse the amount.
Where is that thing?
Page 39, my lord. May I read it, my lord?
Yes.
The executive engineer Sundargarh irrigation.
Too slowly.
Yeah.
Don't be in a hurry. We are not in a hurry.
Yes, my lord. Sorry. The executive engineer Sundargarh Irrigation Division Sundargarh has deposited a sum of rupees 4 crore 38 lakhs 89,000 for disbursement to the displaced families of Kanswal irrigation project as per sanction estimate and rules in force. The displaced families have filed a petition in the High Court challenging the rehabilitation benefits. The High Court in its judgment has observed that the government had not sanctioned the estimated amount proposed for payment of compensation for homestead and agricultural land. The displaced families were in protest since 1991. The Honorable High Court passed the order on 24/8/2000 to pay rehabilitation assistance as applicable to the displaced families within a period of 6 months. The payment has not yet been started, though 12 to 13 years have already been passed. The Additional Secretary to Government in the Water Resources Department has communicated a sanction order of 1 crore payment, 1 crore for payment of rehabilitation assistance to 86 families in a flat rate of 1,72,000 and to 95 families at rupees 1,44,000. There are no further communication received by this office regarding the sanction of funds to raise 339 displaced families. The executive engineer, without mentioning the details of the sanction order and amount to be paid to each displaced family, has deposited rupees 4 crore 38 lakhs 89,000. Therefore, I am to request you to issue necessary clarification as to whether the rehabilitation assistance will be paid at flat rate of 1,72,000 to all 515 families, that means 339 plus 176 who have been paid, excluding the 90 displaced families who have received 20,000 to 20,075 earlier. Those 90 families will be paid 1,44,740 as indicated in letter number so and so. What this is. An early clarification is requested since the matter is now abnormally delayed. This is in 2014. My lord, thereafter 5 proceedings has been there only. Page 42, all the 339 families have been. Page 42, my lord.
When are you going to do? Yet to be sanctioned means how many year more you will take?
Well, last time the instruction was whether they were in the list or not. That we have to
No, now the list is there.
Yes.
And money is also
We will be taking
has been
instructions.
deposited.
Yes.
So 2014 a clarification has been sought for by the director R&R ex officio additional secretary. So ask him to appear tomorrow to virtual.
One decade. 2014, we are in 2025.
Ask him
We are
to
not able
appear
to do
to
it.
virtual mode tomorrow. This as per the order dated 26/3/2025. The Land Council for the state has produced the written instruction. The later dated 13/3/2025 of the Land Acquisition Officer Sundargarh, addressed to Superintending Engineer Rautkala, Irrigation Division Rautkala, wherein it is stated that the 12 petitioners who have filed this petition are in the list of 339 families for whom the compensation is yet to be sanctioned. Stop. Land Council for the petitioners, Mr. Udgata, pointed out the later page
Page 39, Annex 7. Series first place.
placed the later number 142 dated 5/2014 of the collector Sundargarh, which is addressed to the director, R&, ex officio additional secretary to government, WR department, Bhubaneswar. in connection with the rehabilitation assistance to the project affected persons of Kanshabahal irrigation project. In the said letter, it is mentioned as follows. Quote the entire letter. Mr. Udgata submits that even though the amount the has been deposited way back 2014, and clarification has been sought for as to at what rate the rehabilitation assistance would be paid, but no such clarifications have yet been received by the collector Sundargarh, for which there is inordinate delay in disbursement of the compensation amount. Let the director R&R so and so, who is opposite party number.
I have made the secretary.
Have you made him a party?
Yes. OP number 6.
OP number 6 appear tomorrow, virtual mode, to apprise this court about the status of the letter dated 5/2/2014. A free copy of the order be handed over at 10:30. Free copy of the order be handed over to the Land Council for the state for compliance. This letter is taken on record. Yeah.
Item 2.
Yes. You come to the order dated 12/9/2024.
Yes, madam. That is the first
and come to the last paragraph,
Yes, madam.
page number 3.
Yes, madam.
Read it out.
Learned counsel for the petitioner submitted that similar persons have got relief and drew the attention of the court. Paragraph number 9 of the date, so also to annexation 9.6. But fairly submitted that the projects are different, and so far as the case in hand is concerned, it relates to your irrigation, medium irrigation project at CORAM, and seeks some time to obtain instruction as to whether any displaced family under the DO irrigation medium irrigation project at Korangia has got the relief as has been claimed by the petitioner the 8%. So that order on 6/3/2025, order number 6, I have submitted before this honorable court that the petitioner has made appropriate application under the RTA.
RTA.
Today morning I have made a telephone call. He has not received the call and not neither.
No, if somebody is not responding to your application under the RTA Act, the alternative remedy is available. You can prefer appeal against his.
And that instruction, whether he has received or not, that
So,
instruction I have not received.
so you want further time?
Yes.
What time you require?
2 to 3.
2 to 3 weeks. All right. The land counsel for the petitioner. What is your good name?
Yes, Roy. Swapnil Roy.
S. Roy.
Yes.
Not an H. Submits that in terms of the order dated 12/9/2024, he has filed appropriate application under the RTI Act before the concerned authority, but has not received any response, and the matter may be taken up after 3 weeks. Put up this matter after summer vacation. I think first week of June, for a week of June. Yeah.
Item 3.
The Lordship stands with the last order dated 8/2025 now. The Lordship directed to the
Common State Council to produce the entire case record of Annexure 1, that is WL Lease case number 179 of 77.
Is that is available.
Is it ready with you? So that is ready. An order.
At the case is that the petitioner's vendor got the suit land on basis of Jawan
No, no. Please come to the order dated 11/3/25.
grounds taken in the
Be little louder. I said mic thila kuada gala ki? हाँ सेठी माइक तो रहुथिला ना कुआडे गला अछि ऑन अछि तो ओके हाँ
There is the grounds taken in the consolidated read petition relating to the explanation for the inordinate delay in approaching this court in the year 2024 by the petitioner while challenging the order dated 29/4/2099 passed by the ADM Khurda in revision case number 57 of 98 by the Annexure 3. The vendor of the petitioner, namely Pulak Behari Samantrai, got the land in question by way of Jawan lease. For the copy of lease deed has not been annexed to the read petition, though the order passed in WL case number 179 of 1977 has been annexed to the read petition as Annexure 1. In order to appreciate the contents raised by the Learned Counsel for the parties, let the Learned Counsel for the petitioner produce the lease deed granted in favor of the Pulak Behari Samantrai.
Have you filed it?
My lord, as per my instruction, my lord, in Jawan lease, no lease deed was made. And the suit land has been recorded in favor of my vendor on the basis of the lease case.
No, you that was transferred to you from the person in whose favor that lease was granted. So the question is that whether that Jawan lease permits that he can transfer that land in your favor or not. So that it can be ascertained when we see the terms and condition which is there in the lease deed. How can you say that just ମାନେ ଓରାଲି ତ ହେଇନଥିବ ନା ଆପଣଙ୍କୁ ଗୋଟେ ଡିଡ୍ ହେଇଥିବ ଯୋଉ ବେସିସ୍ ରେ ଆପଣ
ଗୋଟେ କେସ୍ ହେଲା
ଇଏ
ଗୋଟେ କେସ୍ ହେଲା ମୋ ଭେଣ୍ଡରଙ୍କ ନାଁରେ ଗୋଟେ କେସ୍ ହେଲା that is Jawan case. The Jawan case recorded ହେଲା ମୋ petitionerଙ୍କ ଭେଣ୍ଡରଙ୍କ ନାଁରେ that is Annexure 1.
No. It's Annexure 1 is there. There must be Annexure 1 ରେ ଆପଣଙ୍କୁ probably sanction ହେଲା.
No. ମୋ ଭେଣ୍ଡରଙ୍କ ନାଁରେ
ବୁଝୁଛି ଆପଣଙ୍କ ଭେଣ୍ଡରଙ୍କ ନାଁରେ sanction ହେଲା, but that's an order. On the basis of that order, a lease deed is to be executed. We have seen it in other days that ଏତିକି ବର୍ଷ ପର୍ଯ୍ୟନ୍ତ ଆପଣ ସେଟାକୁ ଇଏ କରିପାରିବେନି ଯୋଉ ପର୍ପସ ପାଇଁ ନେଇଛନ୍ତି ତା ବିନା ଅନ୍ୟ ଏଗୁଡାକ ସବୁ ତା ଦେହରେ କଣ୍ଡିସନ ହିଁ ଥାଏ ହଁ ସେଇଗୁଡାକ ଆମେ ଦେଖିବାକୁ ଯାଉ ଯେ ତା ଦେହରେ କିଛି କଣ୍ଡିସନ ଅଛି କି ଯେ ଏତିକି ବର୍ଷ ପାଇଁ ପର୍ଯ୍ୟନ୍ତ ଆପଣ ତାକୁ ଆଉ କାହାକୁ ମାନେ ବିକି ପାରିବେ ନାହିଁ ଏସବୁ କଣ୍ଡିସନ ଥାଏ ଲିଜ୍ ଡିଡ୍ ରେ ଆପଣ ଯଦି ଜବାନ ଲିଜ୍ ଟା ଆପଣ ଗୋଟେ ନେଇଛନ୍ତି ଆପଣ ଗୋଟେ ମନେକର ଆପଣଙ୍କୁ ଏଗ୍ରିକଲଚର ପାଇଁ ଦିଆଯାଇଛି ଆପଣ ତାକୁ ନେଇଯିବେ 15 ଦିନ ପରେ ବିକିଦେବେ ଆଉ କାହାକୁ so that is not the purpose for which Jawan lease is granted right so ଆମେ ଦେଖିବାକୁ ଚାହୁଁଛୁ ଯେ Jawan lease grant ହେଲା deed ର ତାର terms and condition କଣ ଥିଲା ଆପଣଙ୍କୁ ସେ କେବେ ମାନେ by way of registered sale deed ବିକିଲି ଗଲା ସେ lease deed ତାକୁ permit କରୁଥିଲା ନା ନାହିଁ ଯେ ଆପଣଙ୍କୁ ବିକିବା ପାଇଁ ଏଇ ସବୁ ଜିନିଷ ଦେଖିବାକୁ ଗଲେ lease deed ର recitation ଟା ଦରକାର ସେଇଥିପାଇଁ କୁହାଯାଇଥିଲା ଆପଣଙ୍କୁ ଆଣିବା have you got the copy of that lease deed?
No.
Obviously you are that record ରେ ଖାଲି sanction ହେଇଥିବ ଯେ ତାଙ୍କର
favor
your vendor had transferable right.
That is the main thing which is to be.
If the land will be settled under the OGLS Act,
Unless the lease is seen, it can't be decided. So place on record the lease.
Jawan lease ରେ ଆମେ ଦେଖିଛୁ ସେଟା ଗୋଟେ ଫର୍ମ ଟାଇପ ର ଥାଏ ଦେଇକି ତା ଦେହରେ ଲେଖା ହେଇଥାଏ ଗୋଟେ କଲମ ତା ଦେହରେ ଅଛି ସ୍ୱତନ୍ତ୍ର ହଁ so ଆପଣଙ୍କୁ you are taking time it's not that we have not seen we have seen such Jawan leases in which this terms and conditions are very well mentioned that is why what you are saying that ନାଇଁ ସେମିତି କିଛି deed ନଥାଏ କଣ ଖାଲି order pass ହେଇକିନା ଆପଣଙ୍କୁ ଜମିଟା ଦେଇଦେବେ ଜମିଟା ମାଲିକ ହଉଛି ସରକାର ଆପଣଙ୍କୁ ଗୋଟେ Jawan lease ରେ ଆପଣଙ୍କୁ ଦିଆଗଲା there must be
Condition.
हाँ ସବୁ ଜିନିଷ ଲେଖା ହେଇଥାଏ ଯାହା ଯାହା ବର୍ତ୍ତମାନ ଆମେ କହିଲୁ ଯେ କଣ ପାଇଁ ତାକୁ ୟୁଜ କରିବେ କେତେ ବର୍ଷ ପାଇଁ ଆପଣ ତାକୁ ଇଏ କରିପାରିବେନି ଏବଂ ତାକୁ ଯଦି ବି ବିକିଲେ ମାନେ you are to take permission from the authority. Suppose ଆପଣଙ୍କର necessity ଆସିଲା ତାକୁ ଚାହୁଁଛନ୍ତି ଆପଣ ସେଇ ଯୋଉ ବର୍ଷଟା ପାସ୍ କରିଗଲା ତାପରେ ଆପଣ ଚାହୁଁଛନ୍ତି ତାକୁ ଆଉ କାହାକୁ ବିକି ଦେବା ପାଇଁ ତା ଦେହରେ ଥାଏ ଯେ that is to be the consent is to be obtained from the government. And in several cases these matters have been dealt with. Jawan lease ର ଯୋଉ format ଅଛି
Section 6A of the Whaler Act.
ହଁ ସେଇ ସବୁ ଯବାନ ଲିଜ୍ ର କେସ୍ ଗୁଡାକରେ ଏ ସବୁ ଡିଲ୍ ହେଇଛି କଣ ଆପଣ ଯୋଉ ଗୋଟେ ବର୍ତ୍ତମାନ ଆମକୁ କହୁଛନ୍ତି ନା ଯବାନ ଲିଜ୍ ର କିଛି ଡିଡ୍ ହିଁ ନଥାଏ that's not correct. There is a deed. It may not be in that way ଯୋଉଟା ଆପଣ କହୁଛନ୍ତି ଯୋଉ OGLS ର but that format is there. ତେଣୁ ସେଇଟା ନ ଜାଣିଲେ ଆମେ କେମିତି ଇଏ କରିବୁ
With Lordship's permission, my lord, the vendor of the petitioner is not interested to this case. If the Lordship directed the state government to produce that list deed, my lord, because the list deed is between the my vendor and the government, my lord. My vendor and the government. So this deed was made between the my vendor and the government.
No, you said that I will produce. ଆରେ ଆପଣ ପରା ସମୟ ନେଲେ
My lord, but,
ଆଉ ତାଙ୍କୁ ଆମେ କହିଥିଲୁ ସେ କେସ୍ ରେକର୍ଡ ଟା ପ୍ରଡ୍ୟୁସ କରିବାକୁ ସେ ତ ପ୍ରଡ୍ୟୁସ କରିଛନ୍ତି
but
ତ ଆପଣ ଯାହାଠୁ ଜମି କିଣିଲେ ତାର ଟ୍ରାନ୍ସଫରେବୁଲ ରାଇଟ୍ କି ଅଛି ନା ନାହିଁ ସେଇଟାର ତାର ଡକୁମେଣ୍ଟ ଦେଇନାହାନ୍ତି ଆପଣଙ୍କୁ ଆଜି ଆପଣ ଭେଣ୍ଡର ଆଜି ହାଇକୋର୍ଟକୁ ବିକି ଦେଇଥାନ୍ତା ରେଜିଷ୍ଟର ସେଲ୍ ଡିଡ୍ ରେ ତାହେଲେ ଆପଣ ନେଇଯାଇଥାନ୍ତେ ତାଠୁ ତ ଦେଖିବାର ନା ଡକୁମେଣ୍ଟ ଦେଖିବେ ନା ତାର ଟ୍ରାନ୍ସଫରେବୁଲ ରାଇଟ୍ ଅଛି ନାହିଁ ତ ସେ ଡକୁମେଣ୍ଟ ତ ଆପଣ ପାଖରେ ରହିବା କଥା କେମିତି ନାହିଁ କହୁଛନ୍ତି ଆପଣ ନା ସେଥିରେ କିଛି we will presume that there is something adverse against you for which you are not producing it. Out the presumption is that had it been if it would have been produced, it would go against you. That is why you are withholding that document from the court.
Because now the vendor is not interested. For that reason, I am unable to receive the list deed from my.
ଯେତେବେଳେ ତାଠୁ କିଣିଲେ ସେତିକିବେଳେ ତ ଆମ ଫଣ୍ଡାମେଣ୍ଟାଲ ଜିନିଷଟା ହଉଛି ନା ରଖିବା କଥା ଆପଣ କହୁଛନ୍ତି ଆପଣ ସେଦିନ you said on that day that you will produce.
Thereafter, I contacted my client, but he stated that my vendor is not willing, so he may not give the list.
When you purchase from your vendor, have you inquired that has he have the transferable right or not? You have not seen the lease, nothing. Simply purchase.
In my sell deed also simply purchase, my lord.
କେମିତି ହବ ଆପଣ ଗୋଟେ କ୍ଲେମ କରୁଛନ୍ତି ତାର ବେସିସ୍ କିଛି ଥିବା ଦରକାର ନା
My lord, lease deed was granted in the year 1977, but purchase 94, my lord.
କେତେ ବର୍ଷ ପାଇଁ ଆପଣ ସେ ବିକି ପାରିବ ନାହିଁ ତାପରେ ଯଦି ବିକିବ ତା ଦେହରେ ସରକାରଙ୍କର ଅନୁମତି ନେଇ ବିକିବ ଏସବୁ ରହିଛି ମାନେ ଯବାନ ଲିଜର ଗୋଟେ ଫର୍ମ ଥାଏ ତାର ଇଏ
ଯୋଉଟା ଆପ୍ଲିକେସନ ଅଛି
ଯୋଉ ସେଲ୍ ଡିଡ୍ କରାହେଇଛି ତା ଦେହରେ ବି ଲେଖା ନାହିଁ ବୋଧେ ଯେ ଏଟାକୁ ଯବାନ ଲିଜ୍ ରେ ସରକାରଙ୍କ ଇଏ ପାଇଥିଲେ ଆଉ ତାହେଲେ ଆପଣ ପ୍ରାଇଭେଟ ଲ୍ୟାଣ୍ଡ ନା କଣ ଆପଣ ଯାହା ଇଏ ବିକିଦେଲା ଆପଣଙ୍କୁ ଲେଖିଛି ତହସିଲ ବୃତ୍ତିର ଆମେ ନିଜ ନାମରେ ରେକର୍ଡ ହେଇଛି ତେଣୁ ଆମର ଦରକାର ହେଲା କେତେକ ଆବଶ୍ୟକ ଖର୍ଚ୍ଚ ପାଇଁ ତେଣୁ ଆମେ ତା ଦେହରୁ ବିକି ଦଉଛୁ ଯେମିତି ଗୋଟେ ପ୍ରାଇଭେଟ ଲ୍ୟାଣ୍ଡ ତାକୁ ସେଟା କୋଉଠି ଲେଖା ହେଇଛି କହୁନାହାନ୍ତି ଦେଖୁନାହାନ୍ତି 18 ହଁ ପ୍ରପାରା
Second paragraph.
ହଁ କହୁନାହାନ୍ତି
ଶୀର୍ଷ ତହସିଲ ବର୍ଣ୍ଣିତ ବୃତ୍ତି ଆମ୍ଭ ନିଜ ନାମରେ ରେକର୍ଡ ଦରରେ ଥାଇ ଭୁବନେଶ୍ୱର ତହସିଲ ଅଫିସରେ ଓଡ଼ିଆ ନଥି ନମ୍ବର 179/77 ର ମୁତାବକ ଲିଜ୍ ସୂତ୍ରରେ ପଟ୍ଟା ପାଇ ବୃତ୍ତିରେ ମାଲିକ ଦଖଲକାର ଅଛୁ ନାହିଁ
ଲିଜ୍ ସୂତ୍ରରେ ମାନେ କହିଲେ ଜବାନ ଲିଜ୍ ବୋଲି ଆପଣ ଯୋଉ ୱାର୍ଡଟା ୟୁଜ କରୁଛନ୍ତି ସେଟା କାହିଁ?
That they have mentioned the case number, and the case number is equal to the Jawan League 179, that is Annexure 1.
সেটা WL
Consider WL.
Letter ବି ସୁଝେଇଲା ଉଠେଇଥିଲା ହେଇଯାଉ ସେଇଟା ଭାଇ କିଛି ନାହିଁ। Director to say that colloquial Ishamantrai has been declared eligible for the concession of land. And the present petition, the allotment of land in favor of Kogoroveri may please be intimated to so and so. And the conditions for
So, for the interest of justice, since his vendor is not now cooperating, so the document you verify whether it is available that lease deed. So, because admittedly, your document shows that lease has been granted in favor of that
Golok Bihari.
Samant.
Just see this document and the allied document with this. Just verify and tell us. This document shows that it has been validly,
Exactly.
yes.
Let me undo the provide order dated 11/3/2025. The London Council for the petitioner was asked to produce the lease deed granted in favor of Golok Bihari Samantrai, which is stated to be a Jawan lease. The Land Council submits that since the vendor is not cooperating, that is how he is not able to produce the same. He submits that the Land Council for the state may be asked to produce such deed. Stop. The Land Council for the state has produced the case records of WL case number 179 of 1977 from Tahsildar Mishra, and on verification of the said case record, it appears that the vendor of the petitioner, namely Golok Bihari Samantrai, has been declared eligible for the concession of land. And the allotment of the land was in favor of the vendor of the petitioner, was directed to be intimated to the Home Department of Government of Orissa from the later dated letter number 1943 oblique POLL bracket with 8 bracket rep 4 -1/77 dated পর্যন্ত 26/4/1977 ହେଲା, which is addressed to the district magistrate Cuttack. ହେଲା, the Land Council for the Land Council for the state obtain instruction regarding the availability of the lease deed with the government and to produce the same on the next date. The case records of WL case number 179 of 1977 be retained by the Land Council for the state till next date. है ना? And of this matter after summer vacation. ये जो पेज रो गोटे जेरोक्स करिकिनी रखि दियंतु ड्राफ्टिंग जो येटा ऑर्डर करेक्शन कलाउ करतारो आ बाकी सब फेरिबे माने सबुडा फेरि देबे यार केवल गोटे जेरोक्स भी तम देबे जो लेटर नंबर देबे सब ठीक से लिखिए अच्छा this is to come along with WPC number 30458 of 2022
Out of 30
out of
57.
out of 30579 of 2022 एवढा सबु से जवान लीज रु सेही लोकर जमी रु एमान सब किनी चली अच्छा ठीक है
Item 4.
they are very important documents please keep it yes the order dated first order was passed on 19/3/25
It has been complied.
complied with yeah
The container is dispose of the representation.
I'm going to order the
I have received your order.
out of received look on the Land Council for the state has produced the compliance order which is taken on record. Land Council for the petitioner also submits that he has received the compliance order. In view of such submission, the content petition is disposed of. It is taken on record for compliance. Yes.
Item 5.
Actually, good on you. But I have challenged the order under annexure settlement. That is also the WLL case.
Which order you are challenging?
Additional sub-collector settlement.
Which order you are challenging? There are number of orders in that
Yes, my
annexure
lord,
6.
annexure 7. Annexure 7, page 57.
Two particular order re annexure 7 ne
59.
order achi.
Yes, my lord.
हाँ.
15 February 2022, page 59.
Have you mentioned in the prayer portion that you are challenging
Yes,
this particular order?
Yes, my lord.
देखिल वो order टाକୁ challenge କରୁଛନ୍ତି କାହାର annexure जो कहउଛନ୍ତି 7 ଏ ସବୁ କଥା କୋଉଠି prayer portion ରେ ଲେଖା ହେଇଛି?
Prepared in favor of the as to why the order passed by the OP number 3, that is the additional sub-collector settlement Bhubaneswar in suit number 256 of 2016 under annexure 8.
annexure 8 ଏଇଟା order dated କେତେ ଲେଖିଛନ୍ତି 15/2/2022 ବୋଲି order date ଲେଖି ନାହାନ୍ତି annexure ଭୁଲ ଆପଣ prayer ତ ଆମେ କେମିତି କ୍ୱାସ କରିଦେବୁ ସେଇଟାକୁ you are to make a specific prayer in the writ petition that एक तो annexure माने number भूल ହେଇଛି annexure 7 तापर annexure 7 ने जेतु 8-10टा order अछि जो particular order टाକୁ challenge କରିଛନ୍ତି that should be mentioned in the prayer portion.
In my writ application, I have mentioned, but in prayer.
आ prayer तो काटी देलेनी total delete कर देलेनी prayer दरकार नथिला आपण जदी writ petition भीतर लिखिचंदी prayer ही दरकार नै लिखिबा ताले prayer टाକୁ total रखि न थांदे prayer नै रखचन amend that prayer portion and file a appropriate consolidated writ petition file करो है ना
आगे
लेखन the petitioner Babita Satpathy has filed this writ petition challenging the order dated 15/2/2022 passed by the additional sub-collector Bhubaneswar bracketary opposite party number 3 in suit number 256 of
16.
2016. The Land Council for the petitioner submits that in the prayer portion, not only the order date has not been mentioned, but also the annexure has been wrongly reflected, and therefore he seeks some time to file an interim application for amendment of the prayer portion of the writ petition. Put up this केवे file करिए
This week.
this week corners, and you will file the interim application during course of this week. Put up this matter next week with the interim application, if any, filed in the meantime, giving copy to the Land Council for the state. Clear?
Item 6.
Pursuant to the order dated 8/4/2025,
Hmm.
I have filed the documents yesterday. The documents means copy of OA application, the counter affidavit filed by
That is not tagged to the file. That is it available? Have you given a copy to the?
you already saw.
We are not the contesting opposite party. Contesting opposite party 2 to 5. They have contested in court below and they have.
No. The prayer is to quash the order dated 6/11/2024 under Annexure 8 passed in OA number so and so. So let us come to Annexure 8. So it appears that 10 applicants are there. You are the applicants before the.
Yes.
8/4/2024, you have reproduced everything.
8/4/2025.
Everything is written.
On being dismissing the original application with the prayer to direction to the on page it appears that on the ground of delay in approaching the land tribunal, the original application was dismissed. On period of paragraph 10 of the 17 number of casualties also regularized observed in the post of however, the Land Council for the petition has not filed the aforesaid 2 orders in which the cases of 17 number of casualties submits that in the original application, state ground has been raised and the opposite parties in their counter affidavit have not disputed the same. Where similarly situated 70 junior to them have been regularized in the post of in 2 pages. Let the Land Council for the petitioner find a copy of the original application filed with pursuant. Source of the counter affidavit filed by Sam. Acha. Appear to send a copy of the response. कौन अपन कहले कौन contesting opposite party?
I am representing the Union of India, only the Ministry of the Telecommunication, but the chairman and managing director Bharat Sanchar Nigam Limited, opposite party number 2 to 5 million, subdivision officer BSNL Digpondi, they have contested in court below and they have filed the objections. We are the formal party.
पर्यंत issue notice ହେଇନି ପରା ଦେଖିବାକୁ just ଚାହୁଁଥିଲୁ
Time of admission,
issue notice ହେଇଥିଲା ଆପଣ ଦେଖନ୍ତୁ ସେଟା ସେ ଏଇ ଗ୍ରାଉଣ୍ଡ ଟା ନିଆଯାଇଛି ଦେଖାଉନାହାନ୍ତି ହଁ ଏଇ ଯୋଉ 17ଟା ଲୋକ ଯୋଉ କ୍ୟାଜୁଆଲ ମଜଦୁରକୁ ରେଗୁଲାରାଇଜ କରାଯାଇଛି ଯୋଉମାନେ କି ହଉଛନ୍ତି ଆପଣଙ୍କଠୁ applicants to junior ବେଲି ଯୋଉ statement ଇଏ କରିଛନ୍ତି ସେଟା କାହିଁକି?
Let me say the case about.
ହଁ ହଁ
I have filed this case
yes
not against any order.
hmm.
I have filed the case relating to the inaction of the opposite party in not regularizing the prisoners.
Hmm. You
I have
just come to your original application. Let us see that. What is your prayer?
The original application kindly see.
OA number 150 of 2017.
Yes.
Okay, let us see go to the relief short plot. Page number 21.
21.
Hmm.
Page number 21.
Hmm.
In view of the facts mentioned in paragraph 6 above, the applicants pray for the following relief: to direct the respondent to observe the applicants in the post of Group D non-test category of regular Mazdoors as left out cases with effect from the date on which the 17 number of casual Mazdoors have been regularized and observed in the post of Group D non-test category of regular Mazdoors within a stipulated time.
That is exactly what we have mentioned already in the order dated 8/4/25. So we asked you to show that where have you taken that ground, and you said that post of in 2 phases. So where is your ground? Let us see about those 17 persons.
That is Annexure 6.
Annexure 6. To this writ petition, or they are in the original application?
Original application of 6 है, it's 6.
Achha, 6. 17 number of provisional appointed regular Mazdoor listed so and so, appointed by so and so, and hereby appointed as the post.
At page 40, list of formally appointed RMs, regular Mazdoor list.
So this was done in 2004.
Yes.
So you approached the London Tribunal in which year? 2017.
I have not approached the London Tribunal against any order about the inaction. And while we were serving as the Mazdoors, the manager administration called for a report from the opposite part number 5 to send the available Mazdoors, name of the available Mazdoors records with their documents for regularization. Now let me see, I have filed today with affidavit the submission. I have prepared it. And
yes, from the submission, you just come to your page 2. 23/6/2024 is the 17 people were observed.
So that is
and thereafter you see your conduct. Subsequently, 29/1/2005, the SDO has called for the report. And 24/2/2005, you again another report. Thereafter, after 4 years, you slept for 4 years. Then in 2009, you gave representation. Again, you slept for another 4 years, 5 years.
Nobody is disputing that you are not working.
2012, second day.
My case is, while working as such, we have approached.
This is not a interpretation. चुपचाप 5 वर्ष पढे 4 वर्ष पढे ताପରେ यसरी अर्थ 2012
the main reason why the prayer has been disallowed is the delay in approaching.
Delay in approaching, there is no delay. My submission is there is no.
By filing representation, you mean to say that the then?
I have not challenged any order. Kindly see, I have quoted the provision also. Kindly see.
No, when the similarly situated persons have already got the benefit, according to you, those 17 persons, the question is that why you did not approach in 2004? Why you did not approach the court that seeking the relief, and in view of that some information was already required information was sought for.
Your real cause of action arose on 2004. You went to the court in 2017.
See the provision of limitation.
Yeah, that is
At
also
page
another
13,
count.
at page 13, section 21.
Page 13.
13, read petition.
Read petition 13.
Yeah. Yeah.
Ground J, limitation. 21.1. A tribunal shall not admit an application A in a case where a final order such as is mentioned in clause A of subsection 2 of section 20 has been made in connection with the grievance unless the application is made within 1 year from the date on which such final order has been made. It is not applicable to my case.
Next.
B. In a case where an application or representation such as is mentioned in clause B of subsection 2 of section 20 has been made and a period of 6 months had expired thereafter without such final order having been made within 1 year from the date of expiry of said period of 6 months.
So you are coming.
You are coming under.
You are coming under this. Why?
No, this is not applicable.
Why you say so?
In a case where an appeal or representation
You have submitted the representation in 2005.
such as is mentioned in clause B of section 2 of subsection 2 of section 20. Kindly see subsection 2 of
Administrative
section
Tribunal
20 has been made.
Just a minute. Let us see that. (22)(b).
This is not applicable because
Just let us see.
ingredients are not
22B. Yes.
No final order.
Where no final order has been made by the government or other authority or the officer or the other person competent to pass order with regard to the appeal preferred or representation made by such person if a period of 6 months from the date on which. So you are coming within that. You have submitted
any appeal.
No, representation.
Representation, it is not against the representation.
You have given the date chart that you have submitted the representation on.
Kindly see
2009, 2012.
21.1 AB.
So just a minute. Where is the date chart he has given?
Representation, applicant representation.
21/7/2009 ଏଇଟା ଯୋଉ ଲେଖିଛନ୍ତି ଏଇଟା କଣ ଭୁଲ ଲେଖି ଦେଇଛନ୍ତି ଆପଣଙ୍କ ଯୋଉ ଡେଟ୍ ଚାର୍ଟଟା
Date chart also.
ହଁ ଏଇଟା ତ ଏଇ ଯୋଉ 9 ନମ୍ବରରେ ପେଜ 3 ରେ ଡେଟ୍ ଚାର୍ଟରେ ଲେଖିଛନ୍ତି 21/7/2009.
Applicant sent representation dated 21/7/2009. Annexure 4. For their absorption in view of the fact that 17 casual modules were absorbed in group B post non-test category of regular modules with effect from 1
So if 6 months passed from the date of representation and no order has been passed on your representation, then within 1 year from the date of expiry of the period, you are to file the application before the tribunal. Otherwise, it would be barred.
1 year, 6 months.
1 year, 6 months term.
21.
Instead of doing that in 2012, you repeated another representation.
21A B.
21(1)B.
Because the ingredients of section 21(1)B has not been fulfilled. Therefore, 21 1B is not applicable.
How you say so? That is why we are asking when it is clearly mentioned
I am
that
reading.
in case where leave that unappealed, in case where a representation such as mentioned in clause B of subsection 2 of section 20, we have just read it, has been made, and you made that representation on 21/7/2009, and a period of 6 months has expired thereafter. Period of 6 months obviously expires in the month of, let us say, January. Without such final order has been passed, then within 1 year from the date of expiry. That means, as my esteemed brother has pointed out, the total period you are to file the writ within 1 year and 6 months from the date of representation, submission of the representation. That would be maximum. It would be the, let us say, 2011 January. But again, you submitted another representation. So there are number of decisions that by filing this number of representation year after year, you cannot.
That is not my case.
What is
My
your case?
solution is,
Yes.
I have not approached the tribunal against any order of any authority.
No, you might not have approached against order, but your cause of action arose at a particular point of time. That is 1.5 years after you submitted the representation. So the limitation appear as per section 21.
My lord, they call for the names from the authority for absorption. Kindly see, I am reading the red chart. At that point of time, you could have called that this is the representation, and they have called for, but no action has been taken providing the names, so or the information. The tribunal could have directed the authority to do the needful. You sat over the matter. You did not do anything. Filed another representation. So in this way, it went on and on.
Even if you stretch your limitation in the general clause at 21(2), that limitation is 3 years. Even if you stretch it, and the limitation recon from the date 21/7/2009. Even the benefit of 3 years is given to you, even then it is beyond limitation. Because the limitation recon from the first representation which you have given. Unilateral representation will not extend the
that is not
limitation.
My case. I am not saying that the representations were made from April to April, therefore I am in time. That is not my
That
case.
is your list of dates is. That's your list of dates. You have said that.
No, I have said that the representation has been made, and thereafter they again called for the names for absorption.
On merit,
page 2.
On merit, your case has not been dismissed by the London Central Administrative Tribunal, but on the ground of limitation, and the provision has been quoted. This very provision which we are reading out together, that has been quoted, and the London Tribunal has said that since the and taken note of also the decision of the Honorable Supreme Court in that Ramesh Chandra Chand Sarma. That case also, this 21(3) has been.
Come to page 47. Page 47, last 3 lines. Page 47 of a writ petition. The tribunal has taken note of this fact. Representation dated 21/7/2009. Since no action was taken on their representation, they have again submitted a representation on 3/5/2012, mentioning therein that in the year 2009, the divisional so and so. Which is a representation you have given. That's what the tribunal records. 47.
I have approached the tribunal against the continuing delay.
No.
It is a case that continuing delay of taking final order in my case, because they themselves have asked the opposite partner of High to send the names.
So opposite it is like as if it's a continuing offense.
Just
continuing
like that.
delay. That is
Just
not
like that.
applicable when the provision of that administrative tribunal specifically indicates that by such method you cannot approach at your whim and pleasure
That is
at
not
any
my
point of
case
time.
at all. That is
So
not
in
my
this,
case at all.
suppose after 40 years, you will just after 3 years, each 3 years you will just go on filing an representation, and you 40 years you will come to the tribunal claiming for the relief. That cannot be allowed. That because of the
My lord, I had about 10 cases.
yeah.
That has been, the Honorable Court has directed to consider the case and for appointment as regular.
No, unless the you see, unless the provision has been dealt with by this court and analyzed, and a ratio is there in that, merely because we pass the order. No, it's all right. You just consider the case on merit. That is not the that is not applicable or binding effect or not. So, question is that whether this point which you are now pressing or this provision has been dealt with in those decisions, and considering this that yes, even in such circumstances also, um, where the representations have been made year after year, so that is to be held as a continuing cause of action, and the uh, tribunal is to condone the delay and entertain the and pass the order on merit. Whether that has been done in those cases or simply just this direction has been passed in those 10 cases which you are referring.
About 5 cases of our High Court.
I'm telling, we are asking you a pertinent question. If those 5 cases has dealt with these provisions, you can show us.
They approached the court 10 years after, and court directed to regularize this. And my lord, their case is Uma Devi's case. Their case is Uma Devi very recently, 2-3 days before filing this application, Honorable Supreme Court has said
order
the present case,
order of precedent value ଯେତିକି ବେଳେ ଆସିବ ଯୋଉଠି provision ଗୁଡାକ analysis କରାଯାଇକି ଦିଆଯାଇଛି, ଏମିତି ଗୋଟେ order pass କରିଦେଲେ which is against the decision of the Honorable Supreme Court that has been quoted here.
No, see that decision, my case is that decision is not applicable in the facts and circumstances of the case.
Yes, argue the matter. Argue. We are ready to hear. We are hearing you. Argue. Bring those cases. If you have got it, place it. We'll see that.
Sir, kindly see the submission supported by affidavit which I have filed. The above mentioned OA application number 115 of 2017 was post of Group D, non-test category of regular Mazdoors of BSNL. Even though about 17 casual Mazdoors working under the Berhampur Telecom district of BSNL have been absorbed in the permanent post of Group D, non-test category of regular Mazdoors on the ground that the same is discriminatory, violative of Article 14 and 16 of the Constitution of it. This is my case. The factual matrix leading to the present filing of the OE is 1997. From the year 1997, the petitioner numbers 4, 5, 7, 8, and 9 have been working as casual Mazdoors.
Mr. Jena, we are making it very clear. The Lennon Tribunal has not dealt the matter on merit. So
Yes,
we are not going to touch on merit. So you are to address us on the point of limitation. If we feel that you are really overcoming that hurdle, then we'll remand the case to consider the matter on merit.
Yes.
Because he has not considered the matter on merit. They have not filed any counter on the merit. So how we will adjudicate the matter on merit?
These submissions, my submissions relating to their conclusion that it is time bar.
Please, ଆପଣ limitation ଉପରେ ହିଁ argument କରୁଛନ୍ତି।
Limitation ଉପରେ ଏଇଗୁଡା limitation ଟା ତ ଏମିତି ଗୋଟେ ଖାଲି ନାହିଁ ଯେ ଖାଲି
No, no, no.
ଏଇଟା ପଡିବ
Yes,
judgment ଟା
yes,
ଏଗୁଡା fact ନେଇକି limitation ଟା ଇଏ ହବ
yes,
basic on facts.
yeah.
2000 from the year 2000 petitioner number 1, 2, 3, 5, 6 and 10 have been working in the DSNL establishment uninterruptedly as casual workers. 15/10/2003 while the applicants were working, sir, kindly see, while the applicants were working as such, the Divisional Engineer Administration on 15/10/2003 directed the SDO Digpondi, opposite part number 5, to send the list of casual Mazdurs working under him in Digpondi subdivision for regularization. I have not applied for regularization. They have been directed to send the names. Then 3/11/2023, pursuant to the aforesaid letter dated 15/10/2003 of the Divisional Engineer Administration, the SDO Digpondi, opposite part number 5, by letter dated 3/11/23, Annexure 1, sent the list of casual Mazdurs working under him to the Divisional Engineer Administration for regularization along with supporting documents. That is 3/11/2003. That is their correspondence. Then 23/6/2004, the AGM administration for and on behalf of the Chief General Manager, Eastern Telecom Project, Calcutta, by letter dated 23/6/2004, Annexure 6, informed the Chief General Manager, Telecom, Odisha Telecom Circuit Bhubaneswar, GM Telecom, SSA Barampur, GM, DGM, MW Project, Bhubaneswar, DMWP, Barampur, etc., and others concerned officers of the BSNL that 17 casual Group D Mazdurs have been regularized and appointed in Group D post non-test category of regular Mazdurs. They have not had also during that period. They have appointed 17 Mazdurs, ignoring our names, and no reason has been given that why we were ignored.
Then the cause of action in your favor arose on that day when your names were dropped.
Well, it is between themselves, the correspondence are interdepartmental correspondence.
Interdepartmental correspondence not culminated into a final order is not to be taken into consideration.
Yes.
If it is culminated to a final order by which you are aggrieved, the cause of action arose.
No order has-
That's the law. That's the law. You can't change the law.
My submission, I
See, all these things you read, these are interdepartmental communications.
yes.
And the interdepartmental communications culminated to a final order. That is 23/6/2004. And this final order, by the final order, you are aggrieved.
That
So
is
cause
not-
of action arose on that day.
That is
As
not
simple as that.
That is not a final order.
You 7 people were given appointments, regularized. That's the final order. Dropping you,
17 not dropping me.
not considering you, whatever terms you.
And it came to your
17
knowledge
persons
for
out of
which
the list.
no, it came to your knowledge for which also you submitted the representation.
2009.
2009.
Okay, we extend till 2009. Knowledge.
So yes,
Even then,
submitted my representation saying that we should have been also regularized
yes,
during that period.
yes, you benefit of that 2004 judgment order should have been given to you.
My submission is it is not final order passed against me.
No, leave it.
They have not had me.
We are on 21/7/2009. We are on this. Let us say, at least you cannot deny at this moment that as on 21/7/2009, you are not aware that 17 casual Mazdurs have been absorbed in Group D post. That you cannot deny.
Yes.
Because on that basis, you also claim for absorption, right? And that is the reason why you submitted the representation under Annexure 4 on 21/7/2009. Now, at this moment, we are to go to those provisions which you read 21 and these other provisions.
Now come to your representation, is page 36. You have very categorically stated that 17 people you have been given, so we were deprived.
Yes.
Then
Yeah.
Knowledge is there. Knowledge, see, come to page 36, your representation of 2009. First representation. (36). Second paragraph.
We entered into BSL service as
Second paragraph. Yes. 97.
On our representation, SDO Telegraph Linkpoli has sent the list of casual laborers by letter dated so and so 29/1/2005 to the GMTD Barampur for regularization of our service. Then, therefore, we pray before Your Honor to kindly peruse the entire list and consider our case for confirmation of our service in group non-test regular.
No, previous paragraph you say that without our regularization of service, though a group of 17 casual Mazdur workers have been observed and we are deprived.
No, a group.
And that 17 casual workers were observed on 2004.
Yes.
2009 you gave representation. If nothing is passed on, no order is passed in this representation within 6 months or 1 year thereafter.
If any order has been passed, it is without hearing us, without giving any
order
notice.
has been passed.
Therefore,
we are not saying it is the case of your also that any order has been passed on the representation. So let us say that no order has been passed on your representation. Then whether in view of the provision in that Administrative Tribunal Act, you are to go on filing such type of representation one after another after 2 years, 3 years, or you are to approach the court within a particular time as prescribed therein.
So since the matter is with them and no final order has been passed, we have not approached the court in the.
Then why the legislature has used that terms that if you are filing a representation claiming something and the representation is not disposed of, even no final order is passed, then also you can approach the tribunal, and that too within this particular period. Why they have put such limitation in the Administrative Tribunal Act? What is the purpose?
That is keeping in view, if any order has been passed, then that is applicable.
Totally different. Order is different, representation is different. They would not have used that word representation. ଏବଂ ଗୋଟେ particular paragraph ସେମାନେ ରଖୁଛନ୍ତି ଯେ representation ପାଇଁ ଯଦି ଦେଇଛନ୍ତି authority କିଛି ଶୁଣିଲାନି ଚୁପଚାପ ବସିଗଲା ତାହେଲେ ଆପଣ କଣ
କରିବେ? ଏଠି ମୋ କେସ୍ ହେଲା, while we were working, they called for the names. Our names were sent by the authority to the higher authority.
ଆପଣ ଦେଖନ୍ତୁ ଆଉ ଗୋଟେ ଏକ୍ସାମ୍ପଲ ମୁଁ ଆମେ ଆପଣ ଦଉଛୁ. ଆପଣ ଗୋଟେ ଅଥରିଟି ସେମିତି ଆଡମିନିଷ୍ଟ୍ରେଟିଭ ଟ୍ରାଇବୁନାଲ ଆକ୍ଟ ନଥାନ୍ତା ହେଲା, ଆପଣ କୌଣସି ରିପ୍ରେଜେଣ୍ଟେସନ ଦେଇଥାନ୍ତେ, ସେଟା କନସିଡର ହେଇନଥାନ୍ତା ଏବଂ ଆପଣ ହାଇକୋର୍ଟକୁ ଆସିଥାନ୍ତେ ହେଲା, ହାଇକୋର୍ଟକୁ ଆସିକିନି କରିଥାନ୍ତେ 15 ବର୍ଷ ପରେ ଗୋଟେ ରିଟ୍ ପିଟିସନ ଫାଇଲ କରିଥାନ୍ତେ. ତ ହାଇକୋର୍ଟର ତ ରିଟ୍ର କିଛି ଲିମିଟେସନ ନାହିଁ ଆପ୍ରୋଚ କରିବା. Still then the decisions are there that you are to approach within a reasonable time, not that representation High Court, right? किंतु एठी ଗୋଟେ provision ରହୁଛି, specific provision जे administrative tribunal act रे central administrative tribunal को approach करिया पहले जदि representation ଦେଇଛନ୍ତି ଏବଂ ସେଟା consider କରାଗଲାନି ତାହେଲେ ଆପଣଙ୍କୁ କେତେ maximum ସମୟ ଆପଣଙ୍କୁ ଅପେକ୍ଷା କରିବାକୁ ପଡିବ. ତେଣୁ ସେଇଥିପାଇଁ limitation provision କୁ ନେଇକିନି ଆପଣଙ୍କର କେସ୍ ଟାକୁ ट्राइब्यूनल डिस्पोज ऑफ कर देई
सबमिशन इज लास्ट पेज रे नु लिखिछि सेटा. It amounts to continuing delay, just like continuing offense. Continuing delay.
You see, in spite of all kind of sympathy, that is one side, but the other side is the limitation.
Yes.
So sympathy one side. No. We are also human beings. Judges are not. We are human beings. मजदूर माने एते वर्ष काम करेनी, सिमिलरली सिचुएटेड लोक पाइछंती, से कथा भी आम मन को आसुची, किंतु आमे भूली जीवनी जे गोटे provision got a hurdle create koruchi and you have to overcome that provision. And if we pass the unless we will whatever we have to do that we have to do because some certain procedure has been there to act. So we have to act in accordance with the procedure. If we go beyond that, it will not be permissible.
Well, my submission is their case is the hurdle created by Umadevi case. My submission in the present case is Honorable Supreme Court of India has said Umadevi case, they have cited the Umadevi case and observed that in the case of like this Mazdurs, it is not applicable. I am reading that portion, 2-3 lines of that decision.
You are again adverting to merits of the case. We are not on merits. Non-passing an order in a representation is deemed to have been rejected. Therefore, 6-month limitation is prescribed. Thereafter, 1 year. As simple as that. Why are you going here?
Limitation upon विचार करी परिबे मेरिट अपन तो जीवन लेट सोलन की खाली को मत लिमिटेशन हिची कि नहीं इट इज नॉट अगेन सही तरह मु कहू जे देखो Honorable Supreme Court of India, their case is Umadevi case. The respondent employer placed reliance on Umadevi to contend that daily wage or temporary employees cannot claim permanent absorption.
Decision दौचंती हमु गोटे कॉपी दियंतु आमे दी जण देखिबु आपण पढिबे आमे देखिबु आपण निजे रखिले पढ देई गले को डिसीजन
ना मु देबी से एथरे कॉपी देबी जे खाली आगे माने प्राइम
how will appreciate a matter. You'll read a decision, you'll not show us which reference, who decision, who year, party na account, amuku dekhebe. Simultaneously, we can appreciate the matter in a better way. No, we are giving you patient hearing. We are not in a hurry. So, amuku decision diyantu.
Civil appeal number 8157 of 2024.
Please give us a copy, Xerox copy at least.
दे दूं आपण देखंतु हाइलाइट करछि
Umadevi, which paragraph?
Umadevi को से कहले Umadevi is not applicable in the factual circumstances कहि कि से Umadevi टा को काटि देले 14 it is the first case no service better माने Umadevi was the better 14 next page is conclusion.
Yes, just a minute.
3 parts.
Okay. Will be get 19.
General principle deals in limitation principle. Yeah.
My lord, as a officer of the court, my lord, I want this was in OA in para 4.14 and 4.15.
OA number?
That is OA number 150. OA number 150 of 2017. Filed by the petitioner. In his para 4.14 and 4.15.
Just a minute.
Page 19.
4 point?
Page 19, madam.
19, acha.
4.14 and 4.15, the petitioners have taken stand that though the applicant have submitted their grievances several times to the respondent and respondent number 4 also asked for call for the list of casual Madhur working under him from the SDO Dikpondi for consideration of their cases to observe them in Group D, noted as left out cases. Cases of the present applicant were not yet been considered by the respondent for the reason best known to them. Therefore, 415 that the applicant had filed WPC number 20770 of 2016 in the Honorable High Court of Orissa under Article 220 of the Constitution of India, which was withdrawn by order dated with leave to file OA in the honorable tribunal.
That's right. 2016 writ petition.
ଯଦି ଖାଲି leave ରେ ଯଦି delay ନ କରି merit ରେ ଶୁଣିବେ that only
Where
can
is that order? Do you have that order?
ମୁଁ ଜାଣିନି
Do you have that order, writ petition order, where leave is granted to you to file a
So
OA?
that order is presently not available. They allowed my application. He said it is withdrawn.
ଅର୍ଡରଟା ଆପଣଙ୍କର ଆସିଥିଲେ ତାରି ବେସିସ ରେ ଗଲେ ଅର୍ଡରଟା କୁଆଡେ ଗଲା? Ask your client to produce that order.
That may come to your aid. Maybe. We don't know.
that is the only ground.
In pursuance of the order dated 8/4/2025, the London Council for the petitioners filed the copy of the original application filed before the London Central Administrative Tribunal. So also the counter affidavit ଦେଇଛନ୍ତି ତ?
No, counter Union of India has not filed the
contesting वाला ଦେଇଛି
BSNL filed କରିଛି.
ନାଇଁ ସେ ଯିଏ ବି ଗୋଟେ counter affidavit
filed କରିଛି.
so also the counter affidavit filed by କିଏ file କରିଥିଲା counter affidavit?
respondent number 2 to 5
Respondent number ଟା କାଇଁ counter affidavit ଆମେ ଲେଖି
page
ଦଉଛୁ
45 ଯୋଉଟା ଦେଇଛି
just page 45
2 to 5 sit.
देखिए ठीक है 5 that is respondent number 2 to 5 है ना out होची out on order थिला आपके चार पूरा होची तो ଆଉ ଗୋଟେ କରାହେଇଥିଲା ଯେ along with the order dated
Sit available.
ସେଟା
Answer 6.
along with the order dated 14 to 2001 ଆଉ 23/6/2004 ଏଟା
Answer 6.
on perusal of the original application, it appears that so far as the limitation aspect is concerned, grounds have been taken in paragraph number 4.14 and 4.15 as follows for the entire two paragraphs. Let the London Council for the petitioners produce the copy of the order dated 21/2017 passed by this court in WPC number 20770 of 2016. Put of this matter. These are taken on record. Along with the copy of the date chart like this. Affidavit pursuant copy of the date chart produce but date chart this is taken on record. either they do citation copy to so tell us when we'll keep this matter. We are just to produce it next week.
Next week.
केवल से order टा तो produce करियो ना आउ गोटे weeks नेबे समय next week रखियो ना 5 तारीख रे रखियो
5 तारीख में either 6 होगा
6 तारीख रख दो देखो 6 5 2025 yes next
my name will be reflected
Mr. Manoj Kumar Patil and senior panel counsel is present. Yes.
Item 7.
My lord, in this case, the petitioners have challenged the annexure 2, my lord, regarding eviction notice, my lord. My lord, on the last occasion by the order dated 11/4/2025, the Law Council for the state has been directed to obtain instruction whether the building has been demolished or not.
Because in annexure it is mentioned that you are in unauthorized occupation of the land acquired for NS 55 and you are asked to vacate that place by 17/12/2024, or else the structure standing therein would be demolished on 18/12/2024.
My lord,
And since more than 3.5 months have passed, ସେଇଥିପାଇଁ ଆମେ କହୁଥିଲୁ ଯେ ସେଟା acted upon ହେଇଛି କି ନାହିଁ କଣ what is your instruction? Annexure 2 ର status ଟା ଆପଣଙ୍କୁ
my lord, the petitioner in the
who has issued that annexure 2?
my lord,
Annexure 2 has been issued by Tahsildar. Endowment କଣ କରିବ?
That property belongs to the endowment. The endowment has received the amount and the order was passed and pays 30 million.
Annexure 2 ଟା issue କରିଛନ୍ତି କିଏ issue କରିଛନ୍ତି?
ତହସିଲଦାର କମ୍ ଅଥରାଇଜ ଅଫିସର ଲ୍ୟାଣ୍ଡ ଆକ୍ୱିଜିସନ NS
ଆଉ ତାଙ୍କରଠୁ ତ ଆଣିବେ ଇନଷ୍ଟ୍ରକ୍ସନ ଟା ଆଣିବେ ଏଇଟା ଭଙ୍ଗା ହେଇଗଲାଣି କି ନାହିଁ କାରଣ ତା ଦେହରେ ଲେଖା ହେଇଛି ଏଣୁ ଆପଣଙ୍କୁ ଶେଷ ଥର ଜଣେଇ ଦିଆଯାଉଛି ଯେ ସ୍ୱାଂଶ ସ୍ଥାନକୁ ଭାଙ୍ଗିବା କାର୍ଯ୍ୟ 17/12/2024 ଭିତରେ ସମ୍ପାଦନ କରନ୍ତୁ ନଚେତ 18/12/2024 ରେ ଆମେ ଭାଙ୍ଗିବାକୁ ବାଧ୍ୟ ହେବୁ।
They are actually compensation by our side. We have sent the letter, but we have not received the.
No, last order, just see the last order. What was short? Last order.
ଆରେ ବାବୁ କମ୍ପେନସେସନ ତା ଜମି ପାଇଁ ଦେଇଦେବେ ତା ଷ୍ଟ୍ରକ୍ଚର ଭ୍ୟାଲୁ କିଏ ଦବ?
Order ହେଇଥିଲା ଦବା ପାଇଁ।
ସେ ଆପଣଙ୍କୁ କୁହା ହଉଛି ଯେ ଗୋଟେ ପର୍ଟିକୁଲାର ଅର୍ଡର ହେଲା and you 11/4/2025 ରେ ଚୁପଚାପ କେମିତି ବସି ଯାଉଛନ୍ତି? Have you written any letter to no communication has been received? So you ask for some more time. अरे କାହାକୁ ଚିଠି ଲେଖିଛନ୍ତି? ସେ ତ ତାଙ୍କଠୁ ଆଣିବେ ଆଉ କହୁନାହାନ୍ତି ଯେ ପାଇନାହାନ୍ତି ଇନଷ୍ଟ୍ରକ୍ସନ। The learning council for the state seeks some more time to obtain instruction in terms of the order dated 11/4/2015 put of this matter on 5/6/2025. Yes. Right.
Item 8,
In this case, your lordship will kindly see the order dated 19/2/25, madam.
That status of that
Aye,
Khasma lease case number that
Fine.
is KLC 109 of 2016,
aye.
and the first order was passed on 19/2, then 3 adjournments.
Aye.
Yes, what
We
is
have obtained the case record of the Khasmal case, my lord. Here in this case, my lord, as because this is the land of the Kisam, which is Jolasaya, and the government now move that petition.
ଆମେ ଷ୍ଟାଟସ୍ ମାଗୁଥିଲୁ, ଆମେ ତ ରେକର୍ଡ ଟାକୁ ପୁରା କଣ ଆଣି ଆମକୁ ଦେଇ ଦଉଛ, କଣ ହେଲା ସେ କିଛି ଡିସିସନ ନିଆହେଲାଣି?
Petition ଦିଆହେଇନି ବା second page. I'm giving
ଏଟା
the
କେବେକାର 2016 ମସିହାର ଆଉ କେବେ ଡିସିସନ ନେବେ? କୋଉଠି କଣ ଲେଖିଛନ୍ତି କୁହନ୍ତୁ?
The official letter dated 21/4/2025. Last, since the petition has
After receipt of the report from the revenue inspector, further course of action will be taken. So report টা কেবে কল ফর কলে?
Revenue inspector report টা আছে annex ରେ
8/3/24 সেটা 2017 সেটা রিমাইন্ড ହେଇ ସାରିଲା ପରେ
ଆଉ ଗୋଟେ ରିପୋର୍ଟ କଲ ଫର କରିଥିଲେ।
after the guideline, government guideline, 2014 guideline ଏବଂ letter annexure 2 dated 2024 February 24 letter ଅନୁସାରେ ଯେହେତୁ ସେଟା ଜଳାଶୟ ଜମି ତେଣୁକରି ସେଥିପାଇଁ ଗଭର୍ଣ୍ଣମେଣ୍ଟ inquire the matter and settle the matter. That is the as per the government guideline communicated letter dated 1040 dated 8/2024. Further detailed report regarding the flow of title and transfer of the accounts.
ଗୋଟେ ଡିସିସନ ନେଲା ପରେ ରିଜେକ୍ଟ କରିଦେବେ, ସେ ଚ୍ୟାଲେଞ୍ଜ କରି ଆପଣଙ୍କର ଅପରେଟିଭ ପୋର୍ସନ ରେ ଯୋଉ ଏଇ ଲେଟରଟା after receipt of the report of the revenue inspector, further course of action will be taken for consideration of the Khasma lease case. So we want to know that when you called for the report from the revenue inspector, तो ଏଇଟା ଆପଣଙ୍କ ଭିତର କଥା ନା, ତହସିଲଦାର ଲେଖିଦେଲେ ଆମେ ଗୋଟେ ରିପୋର୍ଟ କଲ ଫର କରିଥିଲୁ, ରେଭିନ୍ୟୁ ଇନ୍ସପେକ୍ଟର କହିବ ମୁଁ ଅମିନକୁ ପଠେଇଥିଲି, ଏମିତି ଚାଲିବ ନା କଣ? ତ କେବେ ତାଙ୍କୁ ପଠେଇଥିଲେ, ସିଏ ଯଦି ରିପୋର୍ଟ ଦେଲାନି ତାହେଲେ ଏକ୍ସପିଡାଇଟ କେମିତି ହବ ଜିନିଷଟା? 2016 ରୁ ମ୍ୟାଟରଟା ପେଣ୍ଡିଂ ଅଛି, କେସ୍ ନମ୍ବର ଇଜ ଅଫ 2016. He has filed an application for conversion of the land from Kisam Jalasaya to Kisam Gharawadi with so and so. Case record submitted so and so for approval and on transmission to the so and so. Written from the sub-collector, submission and clarification regarding how the Jalasaya Kisam of land will be permanently settled as per OGLS so and so, and subsequent amendment, but there is no clarification regarding the settlement of Khasmal land under Jalasaya Kisam as per notification so and so. The petitioner has purchased and constructed residential building over the settled land over 25 years. The same may be taken up as for the recent funds of the loan. Further, the detailed report regarding flow of title and transfer of occupation over the suit land is required for So this report has also not stated that when you the RI to inquire and what is the reason as to why he has not submitted the report?
Fact mean my lord, the Jolasaya is not been converted. That's why
ଆପଣ ରିଜେକ୍ଟ କରିଦଉନାହାନ୍ତି, କି ଆଚ୍ଛା କଥା, ଆପଣ ପକେଇ କାହିଁ ରଖିଛନ୍ତି? 2016 ମସିହାରୁ ଆପଣ report ମଗେଇଲେ, that means it is under your active consideration. You have she has applied or he has applied for a particular purpose. So you say that law does not permit what
that has not been annexed for the that has not been annexed for the another letter, that is the February 25, 24 settlement of Khasmal land in the nozzle category of land in the state. That notification come out, government of Odisha. So that basically ବର୍ତ୍ତମାନ try to settle that matter, ଜଳାଶୟ land ଏବଂ Khasmal land settle କରିବା ପାଇଁ process ଅଛି. That's why I'm giving my lordship may grant more time so that
oh, ठीक है. If you are creating some hope, then it's all right, sir. Listen, in pursuance of the order dated 15/4/25, no, in pursuance of the order dated 19/2/2025, the London Council for the state has produced the letter dated 21/4/2025 of the Tahsildar Sadar Qatar, wherein it is mentioned at the end, that after receipt of the report of the revenue inspector, further course of action will be taken for consideration of the Khasmal lease case. The copies of the notification and the letter has been annexed to the written instruction as Annexure 1 and 2. From the letter, it is not forthcoming as to when the report was called for from the revenue inspector and why there is delay in submission of such report. Be that as it may, the Land Council for the state submits that some more time may be granted to obtain some further instruction in the matter, put up this matter after summer vacation for learning. These are taken on record. अच्छा, 8 of them begin.
Item 9.
କହୁଛନ୍ତି ଜଳାଶୟଟା
ସେମାନେ
free ହବାରେ ସେଟାରେ ଆଜ୍ଞା କିଛି ନାହିଁ।
ଏବେ ଡିସିସନ ନଉଛନ୍ତି ପରା ସେ ସେୟା କହୁଛନ୍ତି, ଟିକେ ସେଇଥିପାଇଁ କହୁଛୁ ଯେ ହୋପ କ୍ରିଏଟ କରୁଛନ୍ତି, ତେଣୁ ଟିକେ ଅପେକ୍ଷା କରିଯିବାଟା ଭଲ। ତରତର କଲେ ପୁଣି ରିଜେକ୍ଟ ଫିଜେକ୍ଟ କରିଦେବେ କଣ କରିବେ। Yes, next.
Item 9.
May be taken up next week. The Land Council for the petitioner seeks for an adjournment.
Item 10.
Lands have been actioned for the corporate Bengal irrigation project and a compensation to a state. But rehabilitation and resettlement benefits are not provided till date. Petitioner's representation at Annexure 4, page 23, pending before the opposite party. It is direction be issued to the opposite party number 1 to consider within a stipulated time period.
In the representation under Annexure 4, you have stated that your houses and house structures had been acquired for Rengali irrigation project, Samal. So, where is the documentary proof except your this representation?
Compensation notices are under Annexure 3. Compensation they have paid in the year 2006 at page 19.
अच्छा, एटा कहना रे दी ए नोटिस गुडा
मदन मोहन प्रधान
नो अपन आसंतु Annexure 19 कहउछन तो 19 को पळे आसंतु। ଏଇଟା କାହାକୁ ଇସ୍ୟୁ ହେଇଛି ଲେଟର ଏ ଯୋଉ ନୋଟିସ ଟା
ମଦନ ମୋହନ ପ୍ରଧାନ ପିତା କୁଳମଣି
କୋଉଠି
ପ୍ରଧାନ
କୋଉଠି ପାଉଛନ୍ତି?
ମଦନ ମୋହନ
ଆଚ୍ଛା
ପ୍ରଧାନ
ନେକ୍ସଟ ପେଜ ରେ
next week.
ତ କମ୍ପେନସେସନ ପାଇଛନ୍ତି ଯୋଉଟା କଣ ପାଇଛନ୍ତି?
କେବଳ ଟଙ୍କା ପାଇଛନ୍ତି
ମାନେ ଟଙ୍କା ତ ପାଇଛନ୍ତି ମାନେ କଣ ମାନେ
value of the
value of the land and
land.
structure paichanti.
Right.
What further you want?
Now petitions are already displaced. They have taken into possession. So far the resettlement and the
R&R benefit among providing.
Mayor.
ସେଇଥିପାଇଁ ଇଏ କରୁଛନ୍ତି।
Is there any scheme? Is there any scheme existing? Scheme is there?
ସ୍କିମ ରେ ଅଛି R&R ପଲିସି ସମଲ ବ୍ୟାରେଜ ଟା ବୋଧେ 1900 କେତେ ସେ 84 ରେ ବୋଧେ ସେତେବେଳକୁ ଥିଲା ନା କଣ? ସେତେବେଳକୁ ଥିଲା ସେ ଇଏ
Earlier 94 police was in force. Thereafter 2000
family.
ତାହେଲେ
ସେମାନେ collector declared that these family are displaced.
ନାଇଁ ଆପଣଙ୍କର ନୋଟିସ ରୁ ଯାହା ଜଣା ପଡୁଛି their lands have been ଆଗରୁ ସେମିତି ରିପ୍ରେଜେଣ୍ଟେସନ ଦେଇକିନି ଏଠିକି ଆସିଥିଲେ କି ହାଇକୋର୍ଟ କୁ?
ହାଇକୋର୍ଟ ଆସିଲେ
ଆସିନାହାନ୍ତି। କାରଣ ସମଲ ବ୍ୟାରେଜ ର ସେ ଓଭିୟସଲି ସିଏ ଯେତେବେଳେ ହେଇଛି ଏଇ ଯୋଉ R&R ପଲିସି ନଥିଲା ତା ପୂର୍ବର 2006 ଟା ତ ଓଭିୟସଲି ଆସିଲା ତା ପୂର୍ବଟା ଥିବ
94 ରେ ଥିଲା
94
clause 9B was there for the resettlement of the displaced persons. Thereafter 2006 policy came into force. Now 2013 Act came into force.
That is there. So you are hopeful that you will get some result by this type of order directing representation disposal. The writ petition has been filed by the petitioners with a prayer for a direction to the opposite party to provide rehabilitation and resettlement benefits as per 2000 Odisha Swan, so they 2006 policy. The Land Council for the petitioner submitted that though the petitioners have received compensation for the land and stock share which were acquired for the Rengali, what is that project called? Rengali irrigation project. But the R&R benefits have not been provided to them. And in that connection, they have submitted a representation on 3/1/2025 under Annexure 4. ये जो representation आपण ଦେଇଛନ୍ତି ବୋଲି କହୁଛନ୍ତି Annexure 4 ରେ ତାର documentary proof କଣ ଅଛି?
ମାନେ register post
କାଇଁ ସେଗୁଡା ଦେଇନାହାନ୍ତି କଣ କହ? ଏଇ ଖାଲି ଗୋଟେ representation ଅଛି ତାକୁ କେବେ ପଠେଇଲେ ଆପଣ? 3/1/2025 ରେ କୋଉ ୱେରେ ପଠେଇଲେ? ରେଜିଷ୍ଟର୍ଡ ପୋଷ୍ଟ ରେ ତା ଡକୁମେଣ୍ଟ ଟା ଦେବେନି? ଆପଣ ଯଦି ମନେକର ହାତରେ ନେଇ ଦେଇଥାନ୍ତେ ତାହେଲେ ତାଙ୍କର ଗୋଟେ ଏଣ୍ଡୋର୍ସମେଣ୍ଟ ଥାନ୍ତା। ତ ମନେକର ସିଏ ଆମେ ଏଇ ଟାଇପ ର ଅର୍ଡର କରିବୁ ତାପରେ କହିବେ ଯେ ଏମିତି କୌଣସି ରିପ୍ରେଜେଣ୍ଟେସନ ଆମେ ପାଇନୁ। MSS also. Before we pass the order, we are also to see that yes, such representation has been sent to the concerned authority, that is collector and district magistrate on board by issues the copy submitted. We produce the documentary proof if you say that it has been sent by registered post or speed post.
Fresh representation along with the certificate copy of the.
अच्छा कौन लिखिले सुमांशु
And in that collection, they have submitted a representation on the.
However, no post of receipt or any such document has been annexed to the writ petition to show that such representation has been filed. The Land Council for the petitioner at this juncture seeks permission to withdraw the writ petition seeking liberty to file a fresh representation in accordance with law before the concerned authorities for getting the R&R benefit. Accordingly, the writ petition is disposed of as withdrawn, giving liberty to the petitioner. Yes.
Item 11.
May it please launch. Section 1 and challenge matter. Order of the cabinet matter. Here, matter the intent that these petitions are working since 2019 manner. In 2008, there is a restriction not to engage this type of Delhi government. Thereafter, what happened, Manoj? In 2025, but I'm not in the merit of the case, Manoj. I'm very limited prayer, Manoj. In 2025, that is annexure 8 Manoj, they came up with a letter to terminate this type of. Thereafter, what happened? They preferred away. All the beneficiaries, all they preferred away, and the OA were entertained, and interim arrangement were done. But in my way, unfortunately, because that 2025 order rooted from 2008 office memorandum. So in my way, unfortunately, they have not taken note of that 2008.
You come to please paragraph number 4.
Yes,
of the impugned order.
Yes, yes. So Lordship may come to the next page, the operative part. After considering the submission of parties, these were sought clarification from the Learned Counsel for the applicant as to whether the applicants have been thrown out of their engagement in pursuance of the letter dated 16/1/25. Learned Counsel for the applicants has fairly submitted that the service of the applicants have not been terminated, but are likely to be terminated, detrimental to their interest. We find that the order dated 16/1/25 has been issued as a matter of policy to all the head offices of Odisha. It is directing termination of engagement of daily wage casual workers engaged after imposition of ban on engagement of casual workers by office memorandum so and so dated 4/10/2008. Here is the crux matter. The applicant did not challenge the office memo dated 4/10/12/2008, which is the root of the letter dated 16/1/25. The letter dated 16/1/25 has been issued to all the concerned, which the applicants have sought to quash this way without giving details relating to the others, which case might not be similar to the applicant. Further, the applicant did not produce any such document evidencing that any such action has been taken pursuant to the letter dated 16/1/25, adversely affecting their interest at this stage. They have also approached this tribunal without availing of opportunity available to them by way of making representation, which is also a precondition provided under Section 20 of the ATI. Hence, the way at this stage, in our considered view, is premature one and is accordingly dismissed. The Lordship kindly.
What is Section 20?
Yes,
Representation.
Representation has to be given.
You know, kindly have it this way, appear this way.
What is prejudicial? Give a representation and come. What is wrong in it? That's a pre-requirement.
Well,
You have to know.
similarly situated, same letter order challenge that has been entertained, my lord.
They might have given representation.
No, my lord. You also kindly have a glance. I'm just passing this.
ସବୁ ଗୁଡାକ ଗୋଟେ ଗୋଟେ ଇଏ ଭେରିଫାଇ କରିବୁ ନା କଣ?
Well,
ଆଚ୍ଛା ଗୋଟେ
this is the way and the order, my lord.
suppose in one case wrongly
Yes, sir.
one of the he has entertained, he has not looked whether the petition has filed the representation or not, so notice has been issued. ଏଠି ଯୋଉଠି statute ଟା କହୁଛି in view of section 20 you are to exhaust the remedy and you are to file the representation, and that has not been admittedly done, and the letter is dated 16/1/25 ଏଇ ବର୍ଷ ଜାନୁଆରୀ ମାସ ଆପଣଙ୍କୁ ପ୍ରଥମେ ରିପ୍ରେଜେଣ୍ଟେସନ ଦବାକୁ ପଡିବ, ତାପରେ ଆପଣ ଆସିବେ. So that is how they say that
unless you exhaust the administrative remedy, you can't approach the tribunal. That's the law. Section 20 says that.
Yes.
You exhaust your remedy, give a representation. If it is rejected, it is open to you to come. That's what the tribunal says.
And even if it is not also rejected or no action is taken, then also
Then
you can
1
come.
year, 6 months.
1 year, 6 months.
You are absolutely right. But my concern is that when the similar letter, which has been entertained, my lords, so that point of time.
ଗୋଟେ order ଧର ଭୁଲରେ pass ହେଲା, ତା ମାନେ କଣ ତାପରେ ସେଇ ଭୁଲ order ଟାକୁ subsequently follow up ହବ କି? ମନେ କରନ୍ତୁ ସେଟା issue notice ହେଇଯାଇଛି, ତାପରେ other side appear କରିବେ, ସେ ଏଇ point ଟା raise କରିବେ ଯେ ଆଜ୍ଞା ସେ ଯୋଉ remedy ଅଛି exhaust କରିନାହାନ୍ତି, ସେ direct ଆସିକି original application file କରିଛନ୍ତି, ତେଣୁ that is not entertainable. ତାପରେ
my knowledge goes, my lord, I think already they have filed the counter, my lord. So my
see what happens is, and in those petition, the tribunal may pass the final order in this way. Now you are lucky that you got an opportunity.
No, well, that is
finally they may dismiss it, saying that you have not resorted to 20.
The January 25.
So therefore it is good that.
May I pray one thing, my lord, subject to your lordship's approval. So liberty may be granted so that I can file application.
Because that is there, he has stated like this petition has been.
Just a minute. But if the duty of the council was appearing, that point of time he could have asked for the amendment or he could have withdrawn for filing a better application.
Bar council will come.
That is our paternity. That is our paternity.
ସବୁ ଜିନିଷ ଗୁଡାକ ଆପଣ ଲାଇଭ ଷ୍ଟ୍ରିମିଂ ହଉଛି, ବହୁତ ଜିନିଷ କହି ପକଉଛନ୍ତି ଯୋଉଟା କି କହିବା ଉଚିତ ନୁହେଁ, ତାକୁ ଟିକେ ରିଜର୍ଭ ରଖନ୍ତୁ. The writ petition has been filed by the petitioners for setting aside the order dated 5/2/2025 passed by the Land and Central Administrative Tribunal, Cuttack, in OA number 61 of 2025. In dismissing the original application, stop. It appears that have you filed the copy of the original application?
Yes, sir.
Where is that? Annexure?
Annexure 9, ma'am.
Annexure 9.
Page.
The original application has been filed by the petitioners claiming for following relief. The relief sought for lekha hai page internal page 10 achi, running page 63 achi. Taku quote kar de. The Land Tribunal in the interim order has stated as follows, quote paragraph number 4. Hello? Section 20 of the Administrative Tribunal reads as follows, quote the entire section 20. Since admittedly the petitioners have not exhausted the remedy available under section 20 before approaching the Land Tribunal, we find no fault in the impugned order. At this stage, the Land Council for the petitioner submits that liberty may be granted to the petitioner to submit appropriate representation before the concerned authority, highlighting their grievances. It is open to the petitioners to submit such representation in accordance with law.
I am seeking a liberty to file application for the CAD, man. Because once this
File
subject
the representation, then you go to the CAD. Yes, next.
Is 60.
my lord, there is no scope, my lord. Because
Item
matter
12.
subjudice, my lord. Similar matter subjudice, my lord.
Is 60.
Stay has been granted, my lord. These are the copy, my lord. Lordship, kindly have a glance. They are two way and this relief sought for is same, my lord.
6. 6. Out. There is a declaration is out all.
This is for
Though in the paragraph number 6 of the original application, it is mentioned that the petitioners have availed and exhausted all other alternative remedies available.
The format provides it. You have to write there.
And you have written it without even, it can be said that it's an incorrect statement which you have given. Yes, next.
my appearance for the opposite. My lord, the same. Kindly have a glance.
Siddharth Shankar Mishra, and counsel for this one. Yes, item number 12.
Item 12.
Lordship will kindly see order dated 4/4/25.
Structure cost ଆପଣଙ୍କୁ ଦେଇ ଦେଇଛନ୍ତି.
ଆଜ୍ଞା.
Land cost amount has not been refunded to HR, and council has submitted specific submission before this court. But after filing of the representation, the petitioner has not approved this court. This petition approved. Find the part of what do you want now?
I have filed the affidavit, my lord, that after 2019 he has not filed any petition, and in this case, my lord, notice is to go to the ITCO.
Page 40. The amounts have been calculated and were issued from land acquisition officer will give court.
ନା specific case ହଉଛି ଯେ land cost ଟା ଦେଇନାହାନ୍ତି.
Everything being modified and calculation has been made. Page 40.
Page 40. Land value.
Land value ହଉଛି
Land value ହଉଛି 500 କୋଟି 62 ଲକ୍ଷ 23।
ନା ମ ଏଟା ସବୁଗୁଡା land ର ଏଟା ଯୋଉ ସୁରଜ ଇଞ୍ଜିନିୟରିଂ ର structure value ହଉଛି 26 lakhs some odd, my lord.
ଆପଣଙ୍କର plot number କେତେ?
Plot number ଆଜ୍ଞା 314.
Column 7. Column
314 ର column number 7 ରେ land value ଲେଖା ହେଇଛି ଏତିକି, structure value ଲେଖା ହେଇଛି 100.
And they have paid the structure value. I have also annexed that receipt.
So land value ଏଇଟା ହଉଛି ଆପଣଙ୍କର calculation sheet କହୁଛନ୍ତି.
ଆଜ୍ଞା.
Mr. Mahanti, ସେ ଏଇଟା କରିକିନି ଆପଣ compensation deposit କରିଛନ୍ତି ବୋଲି ଲେଖା ହେଇଛି.
ଏଟା ଅଛି ITCO ପାଖରେ, chief general
ପାଖରେ, କିନ୍ତୁ ତାଙ୍କର କଥା ହଉଛି ଯେ କାହିଁକି structure value ଟା ଦିଆଗଲା, land value ଟା ଦିଆଗଲା. So because maybe that land has been provided by the ITCO, so they have retained that amount and not given to you. So if the land belong to ITCO, then how you are entitled to?
ITCO have given me lease for 99 years.
Yeah.
And have also taken the land value in the lease deed, my lord. I have annexed those documents. That's why, my lord, the ITCO is to explain why they have not given.
All right. This petition has been filed by Messrs. Suraj Engineering for a direction to the opposite parties to disburse the compensation amount towards the land value to the petitioner, or to allot equal extent of land in industrial estate at Berhampur. Stop. Pointing out the details of compensation deposited with the Chief Manager IDCO Bhubaneswar, Chief General Manager bracket MSME IDCO Bhubaneswar, as per by the Land Acquisition Officer Ganjam Chhatrapur, as per the letter dated 27/1/2017. The Land Counsel for the petitioner argued that the petitioner is concerned with plot number 314, and it appears from the letter under annexure 6 that the land value along with the structure value has been deposited with the IDCO, but the petitioner has been paid only the structure value. He further submitted that IDCO has given the land to the petitioner by way of lease deed, and petitioner has made payment for such grant of lease, and therefore the IDCO should have disbursed the amount to the petitioner which it has received as per the letter under annexure 6. Stop. Issue notice on the question of admission, indicating therein that the matter shall be disposed of at the stage of admission. Land Counsel for the state accepts notice on behalf of opposite parties number
1.
Stop. So far as the opposite parties number 2 to 5 are concerned, upon karibe land acquisition officer
ମୁଁ ତ ନେଲା ଆଡକ୍ସନ ପଇସା ମୋର ଗ୍ରିଭାନ୍ସ କିଛି ନାହିଁ
ତାର ତ ଲେଖିଦେଲା ପଇସା ତ ଡିପୋଜିଟ ହେଇଯାଇଛି ଏଠୁର ମେନ୍ ରୋଲ ଅଛି
ଆଜ୍ଞା
so far as the opposite parties number 2 to 5 are concerned, requisites for issuance of notice by speed post with proof of delivery shall be filed within a week. Matter be listed after 4 weeks. Counter affidavit, if any, be filed in the meantime. Yes.
Item 13.
Finally, comply the earlier order.
Which order?
Order by the 4/4/2025. I have been directed to file the written consent, my lord. I have applied for RTI, my lord. I have not got it, my lord. Not still 2 weeks time.
What is your submission?
2 weeks time, my lord. For supply that document.
Which document?
Not that document which I have been filed it. I have filed a consent that if other co-shares the land acquisition amount is released in favor of other co-shares.
So if you have not given the written consent, so how can you produce the same?
No, madam, I have filed a consent. Your lordship kindly grant to your lordship directed by the because
direction.
consent is very much necessary. For that reason, your lordship para 6 last part.
Question is that
You have said that you have not given
No, my lord. Your lordship
para 6 at the
five, my
top.
lord.
Then counsel for the petitioner submits that the
That is
petitioner
wrongly
has
typed.
never given the written consent.
That is wrongly typed, my lord.
ଆପଣ ଦେଇଥିଲେ written consent
My
ଦେଇଥିଲେ
lord, my lord,
ଓହୋ ଏଛା never ଟା word ଟା use ହେଇଯାଇଛି
my lord.
has given the written consent
If
that the amount which falls in
other
his share
quarters, my lord.
is to be paid to the artist so and so. So therefore, is entitled to get the compensation in view of the findings so on.
Never follow.
What was the order passed in that title appeal?
Title of the 1/3 share of the present petition, my lord. Possible property.
So say written you consent ଦେଲେ କଣ ଲେଖିଥିଲେ ତା
ଅଦର କୁଆ ସେମାନଙ୍କର ଇଏଟା ତାଙ୍କର ଡିସବର୍ସ କଲେ ଆଇ ହାଭ୍ ନୋ ଅବଜେକ୍ସନ।
ଓ ସେଇଟା ଦେଇଥିଲେ like the reliance counsel for the petitioner. 6 କେତେ ଦିନ ସମୟ ଦରକାର
2 weeks time.
2 weeks time to produce the written consent which the petitioner has submitted before which court?
Land acquisition.
Page 58, Madam Class.
Before the
Page 58, that is recorded. Page 58, finding number 4. Vanamali Ranachya has given it in that he has no objection if he earlier compensation as per a share paid to RT legally at Khatanam.
अच्छा एमती कर दिया Annexure 5 कौन लिखी थी Annexure 4 ना 5
There are 4 of 5
এটা 4 এটা 5 টা ভুল লিখ দিয়েন আচ্ছা the prayer made in this petition is to quash the order dated 5/7/2024 passed by the special land acquisition and who is opposite party number as a special land acquisition and rehabilitation officer Moyurbhanj under annexure 4. In which it has been held that LA compensation for land acquired from notified plots of Khata number 217 cannot be released in favor of the petitioner Bonamari Naik alias Ranosia তার দুইটা নায়ক বনমালী নায়ক alias Ranosia. While passing such order, the opposite party number 3 has arrived at a finding that on 14/3/2022, the finding number 4, page number 15, before payment of LA compensation to the other awardees of HAL ROR 217, the petitioner had given a written consent that he had no objection if LA compensation as per the sayer was paid to the present RTS oblique legal heirs of the RTS of Hal Khata number 217. Stop. As per the order dated 4/4/2025, we asked the Learning Council to produce the written consent which he has given before the opposite party number 3. Stop. Land Council for the petitioner seeks some more time to produce the same. Put up some more time and 2 weeks time before. After put up this matter after summer vacation.
Item 14.
Here, the petitioner, those are some of the villagers of village in Kosi, challenge the annexure 5 at case 39, a notice issued by the Tahsildar in a lease case for de-reservation of the property described in that notice.
Yes. Thank you. Yes.
Spoke your lordships, Lordship may kindly see the definition of the act. It says the collectors include 2 areas. Collectors shall include an additional district magistrate. Lordship kindly keep it in mind, then turn to 3A.
Yeah.
3A says, Miller, I'm placing the government may, by notification in the official gazette, authorize any officer, Lordship kindly keep it in mind, not below the rank of a collector, to de-reserve any land which has been reserved under clause A of section 3, or any government land recorded as gochara, or any portion thereof. 2. Any officer authorized under subsection 1 shall, subject to such conditions and limitations as may be prescribed, have power to de-reserve any land referred to in that subsection or any portion thereof, if such officer is satisfied. Such land or portion thereof, as the case may be, A, is no longer required for the purpose for which it was reserved, or B, can no longer serve the purpose for which it was reserved, or C, in excess of the reasonable requirement for the purpose for which it was reserved, provided that the officer so authorized shall, in assessing the reasonable requirement for the purpose of gochara, follow the prescribed principle laying down the extent of gochar land to be set apart for use of the community. Then your Lordship kindly turn to, here your Lordship has seen that not below the rank of authorized officer means who is not below the rank of collector. So therefore the definition since 2A says collector includes additional district magistrate, then the government in its wisdom has issued a notification 19 your Lordship will get that notification in that book Miller.
এই বইটা আমি ধরছি।
আଜ୍ଞା ସେ ବହିରେ ଅଛି ସାର୍।
କେତେ ନମ୍ବର ପେଜ?
ସାର୍ ସେ ବହିରେ ଏକ୍ସାକ୍ଟ ପେଜ ଆକ୍ଟ ପରେ ଅଛି।
ଏଟା ହଉଛି 2024 ର। ଆପଣ
ନା ମୋର ସାର୍ 21
କୋଉଥିରେ କୋଉଥିରେ
ସାର୍ notification immediately after the act is
immediately after
the notification date ହେଲା 29 ଜାନୁଆରୀ 64।
ହଁ ଏଟା ଅଛି
Sir,
रेवेन्यू डिपार्टमेंट नोटिफिकेशन
Miller.
नंबर टा केते कोंतु
second number টা 3/64
64
6172
हां सेटा कोन
in exercise of the powers conferred by subsection 3A, the Odisha Government Land Settlement Act 1962, the state government do hereby authorize all the collectors of the state. So here they exclude the ADM. They only authorize the collector as the authorized officer. Now your lordship kindly turn to the rules.
The collector's expression includes
Previously,
yes.
But by notification, the state government excludes ADM.
No, it doesn't exclude. It's only collectors.
Only collector.
But definition says collector. Who is collector?
The definition.
How do you read it into?
The definition says collector includes ADM.
Yes.
But the notification says only all collectors.
All collector that includes the ADM. Obviously. You can't. How do you exclude in a notification? How the definition is excluded like that?
Act cannot be taken away by
yes.
No.
All right. Now we come to rules.
Now your lordship, it has no impact over my case.
Yes, sir. Come.
Now your lordship, kindly turn to
1983 rules.
Rules Miller. Rule 4 Miller.
For
de-reservation principle.
Yes. Page 36. Yes.
Miller. Any land which has been reserved under clause A of subsection 1 of section 3 or recorded as gochara may be de-reserved by any officer not below the rank of collector authorized by the state government in that behalf. In making such de-reservation, the following procedure shall be followed. 1. A notice inviting objection to the proposal for de-reservation specifying particulars of the area to be de-reserved and its situation such as village, gram panchayat and town, khata or holding and plot number and extent shall be published in the manner prescribed in sub-rule 5 of Rule 5. A period of 30 days shall be allowed for filing objection, if any, before the concerned Tahsildar. If during the said period no objection is received, the Tahsildar shall submit his proposal for de-reservation, giving justification for the same. 2. In case of objection filed before the Tahsildar, he shall hear the parties on a date fixed by him, and after such hearing shall forward his recommendation to the authorized officer for orders. On receipt of recommendation from the Tahsildar, the authorized officer may, on being satisfied with the grounds advanced by the Tahsildar for de-reservation, accept and modify to the extent if he considers necessary or reject the order passed by the authorized officer shall be communicated to the concerned Tahsildar. When the authorized officer passes order for de-reservation, such order shall be published in the manner prescribed in sub-rule 5 of Rule 5. The Tahsildar shall thereafter make necessary correction in the record of right. While de-reserving any government land recorded as gochara, the authorized officer shall assess the reasonable requirement for the purpose of gochara for using by community in the following manner. In every survey village which is not included,
that is there. So
that is the procedure.
What is your submission?
My submission before your lordship that here before de-reservation, a lease proceeding was initiated by the Tahsildar. In the lease case, objection for de-reservation has been invited. If your lordship says
objection has been invited.
Miller.
Lease case number has been mentioned there.
Miller.
So how do you say that Tahsildar has initiated that?
Tahsildar has given this notice, Miller. Your lordship can see.
Obviously, the notice ta daba kind of statute ta provide.
No, sir. More say sir. Rule 4 jodi conjointly read kariba sir. Tahsildar pakhara objection paila. But objection will be invited by the authorized officer.
No.
If your lordships read Rule 4 in conjunction with section 3A, Miller, it is the authorized officer who has got the power of de-reservation.
How are you prejudiced by the
Miller? I am demonstrating that. I am a villager. This is recorded as gochara. Your lordship can legal.
In this notice,
Miller,
the time has been stipulated to all of you. With जनसाधारण को समस्त को दिया है कि objection ये दबा के था देगा. Objection consider कला परे सेटा de-reserve हबो कि decide करिवे. आपने नोटिस टा केमती चैलेंज करते हैं कौन बेसिस रे
kindly see, sir, what is the notice here? ଏହା ଦ୍ୱାରା ସର୍ବଦଳା ମୌଜାର ସର୍ବସାଧାରଣଙ୍କ ଅବଗତି ନିମନ୍ତେ ଜଣାଇ ଦିଆଯାଉଛି କି ଗୋଷ୍ଠୀ ଉନ୍ନୟନ ଅଧିକାରୀ ଟାଙ୍ଗି 14 ତାମାନେ ଭିଡିଓ ନିମ୍ନ ସରକାରୀ ବୃତ୍ତିକୁ ପଞ୍ଚାୟତ ରାଜ ପାନୀୟ ଜଳ ବିଭାଗ ଓଡ଼ିଶା ସରକାରଙ୍କ ସପକ୍ଷରେ ମିନି ଷ୍ଟାଡିୟମ ନିର୍ମାଣ ନିମନ୍ତେ ହସ୍ତାନ୍ତର କରିବା ପାଇଁ ଆବେଦନ କରିଛି। The application filed by the BDO before the Tahsildar for the purpose of constructing a mini stadium and the extent of land is 6 acres. Now your Lordship may kindly turn to who is authorized even to receive such a lease application. There is a schedule provided to the Act Miller. Your Lordship may kindly turn to rules for a certificate schedule 2.
Rules for a
ଆଜ୍ଞା ରୁଲ ପରେ ପରେ ଅଛି ସାର୍ ମୋ ବହିରେ ପେଜ 47 ଆପଣଙ୍କ ବହିରେ ବୋଧେ ପେଜ 52
ଏ ବହିରେ
ଆଜ୍ଞା
52
2020
just ଟିକେ ରହନ୍ତୁ 52 ରେ ହଁ କୁହନ୍ତୁ
ସାର୍ ଟିକେ 1 ଏଟା ଦେଖିବେ in favor of Department of Government ସାର୍ ସେ ଶିଡ୍ୟୁଲଟା ହେଇଛି in whose favor column 2 ଟା ହେଲା ସାର୍ in whose favor column 3 ଟା ହେଲା officer exercising power. Lordship may kindly gone to 1A in favor of Department of Government. Sir, authorized officer is collector, not the Tahsildar. Even lease application cannot be filed before the Tahsildar. Sir, देखिए exceeding 5 acres है RDC. Sir, क्या देखिए तार
ସବୁଠୁ ଉପରେ ଦେଖନ୍ତୁ ସେଠି
power of
power
sanction
to
is
sanction the
yes, that
settlement.
is
Final
important.
order is to be passed by
Power of sanction is important.
Sir,
at the top. Power to sanction
ସେଟା
the settlement.
ଫାଇନାଲ ସାଂକ୍ସନ ତ ଦବ କଲେକ୍ଟର
Obviously,
କିନ୍ତୁ ଏଇ ଯୋଉ ଗ୍ରାଉଣ୍ଡ ଲେଭେଲ ରେ ଯୋଉ ଜିନିଷ ଗୁଡାକ କରିବାର ଅଛି
ଆଜ୍ଞା
ଏ ଯୋଉ ନୋଟିସ ଇନଭାଇଟ କରିବ ଅବଜେକ୍ସନ ଦ୍ୟାଟ ଇଜ ଟୁ ବି ଡନ୍ ବାଇ ଦି ତହସିଲଦାର
where is that Miller? My submission is
ଏଇଟା ଆପଣ ଦେଖି ଅଭି ପଢିଲେ ପୁରା
ଆଜ୍ଞା
4.1 ଟାକୁ ଆପଣ
sir kindly turn to 4 A B ଅଛି ତ 1 ଆଉ 2
4.1 ଟାକୁ ଆମେ
sir 1 ଟା ଦେଖିବେ
in notice inviting objection
ଆଜ୍ଞା
to the proposal for de-reservation
sir
specifying particulars of area
sir
to be de-reserved and its situation such as village so and so so and so so and so and the extent shall be published in the manner prescribed under sub-rule 5 of Rule 5. Sub-rule 5.
Miller
You come to 5, rule 5.
5.
Sub-rule 5.
Before going to that your lordship may kindly see rule 4.1 says by an officer not below the rank of collector authorized by the state government.
ନାଇଁ ସେଟା ହଉଛି ସେଟା ଡି-ରିଜର୍ଭ କରିବେ
ଆଜ୍ଞା ଡି-ରିଜର୍ଭ କରିବେ
ନୋଟିସ ଟା ଯୋଉ ଦବା କଥା ଅବଜେକ୍ସନ ଟା ଇନଭାଇଟ କରିବା କଥା ସେଠି କୁହା ହଉଛି ପରା by filing an objection before the concerned ତହସିଲଦାର
sir objection ଟା ଫାଇଲ ହେବ ତହସିଲଦାର ପାଖରେ
ହଁ
1 ଟା କହିଲା ପାୱାର ଅଫ ଡି-ରିଜର୍ଭେସନ ହେଲା କଲେକ୍ଟର ର ଅର ଅଥରାଇଜ୍ଡ ଅଫିସର sir ମୁଁ ସେଇ ହିସାବରେ ପ୍ରୋଭିଜନ ଗୁଡା ପଢିଗଲି ସବୁଠୁ ବି ସବୁଠି ହେଲା ଅଥରାଇଜ୍ଡ ଅଫିସର the power to take decision power to de-reserve power to make survey the village power to adjudicate
what you mean to say Mr. Bhuya if we correctly follow that ଏଇ ଯୋଉ ନୋଟିସ ଟା ଦିଆ ହେଲା ଏଇଟା କଲେକ୍ଟର ଦିଆ ହେଇଥାନ୍ତା ଏବଂ ସେ କଲେକ୍ଟର ଲେଖିଥାନ୍ତେ ଯେ ତମର ଅବଜେକ୍ସନ
ତହସିଲଦାର ପାଖରେ ଦିଅ
ଏଇଆ କହୁଛନ୍ତି
ଆଜ୍ଞା
so let us say there is some kind of say ଯଦି how you are prejudiced
sir kindly see
Your case total case is initiation of de-reservation has to be done by the collector and final order has to be passed by the collector. And
objection
but where from you are reading that's not the rule.
Miller the rule says
Rule 5.5 just see.
No 5.5 your lordship kindly
5.5.
Yes the proclamations
Yes.
sir 5 is a manner of settlement of government land 5 does not say regarding this
But where the notices has to be affixed, notices has to be affixed in the Tahsildar's office. That indicates the Tahsildar has to invite and final order has to be passed by the collector.
Kindly see sub-rule 5 of Rule 5B. The proclamation shall be published by beat of drums and by fixing a copy of the same at a conspicuous place in the village or urban area in which the land is situated in the presence of not less than 2% of the locality. If the village is uninhabited the notice shall be published in the nearest inhabited village. A copy of the proclamation shall be published by fixing in the notice board of the Tahsil office.
You stop here. Tahsildar office. The idea of affixing the notice at the Tahsildar office
Not only
indicates that it has to be initiated by him.
No, I am further clarifying. Your Lordship may kindly read further.
Yes.
In the Tahsil office, and a copy shall be sent to the Gram Panchayat or notified area council or municipality as the case may be under which the land is situated. So, Miller, it is only for the purpose of proclamation indicting us.
That's the 4.2.
Miller, had it been Miller, your Lordship may kindly rule.
I would କଥା ଆପଣଙ୍କୁ ପଚାରୁଛି ଆମ let us be clear. ଏଇ ନୋଟିସ ଟା ଯୋଉ ଇସ୍ୟୁ ହେଲା ଅବଜେକ୍ସନ ଇନଭାଇଟ ହେଲା
ଆଜ୍ଞା
ସେ ଡେଟ୍ ଦିଆ ହେଇଛି 15 ଜାନୁଆରୀ 2025 ରେ ସେ ଆନେକ୍ସଚର 5 ଇଣ୍ଡିକେଟ
ଆଜ୍ଞା
ଏବଂ ଆପଣଙ୍କୁ ସମୟ ତା ଦେହରେ ଦିଆ ହେଇଛି 30 ଦିନ ଭିତରେ ନିଜେ ବା ନିଜ ପ୍ରତିନିଧି
ଦେଲୁ ସାର୍
ଆପଣ ଅବଜେକ୍ସନ ଦେଇଛନ୍ତି
ଆମେ ଆନେକ୍ସ କରିଛୁ ସେଟା
ହଁ ଠିକ ଅଛି
ଆଜ୍ଞା
have you whether your application or objection has been considered by the authority?
For consideration, the Tahsildar has invited fixed a date, Miller. That notice also I have given Miller.
Yes.
Your Lordship may kindly turn to Annexure 9 at page 55. We have submitted in objection. Tahsildar invited us to a special hearing. Your Lordship may kindly turn to personal
4/3/2025 ରେ ଶୁଣାଣି ହେବ ବୋଲି
ଶୁଣାଣି ଆଜ୍ଞା ଆମେ ଦେଲୁ ଯେ 4/3/2025 ରେ ଆନେକ୍ସର 10 ଦେଲୁ ଯେ ଲେଖିଲି ଯେ ଆମେ ଗଲୁ ତହସିଲ ଅଫିସରେ ତହସିଲଦାର ନଥିଲେ ଆମେ ଏଇଟା ଦେଲୁ ପୁଣି ଆକୁ ଗୋଟେ ପୋଷ୍ଟ କରିକି ପଠେଇଲୁ ସାର୍ ପୋଷ୍ଟାଲ ରିସିପ୍ଟଟା ଦେଇଛୁ ବିକଜ
ସେ ଡିସିସନ ନିଅନ୍ତୁ ଆପଣଙ୍କର ଅବଜେକ୍ସନ ଉପରେ ଦେନ୍ ୟୁ ଆପ୍ରୋଚ ଦିସ୍ କୋର୍ଟ
ଆମେ
ଗିଭିଂ ଲିବର୍ଟି ଦ୍ୟାଟ୍ ଏଇ ଯୋଉ ପଏଣ୍ଟସ ଆପଣ ନେଇଛନ୍ତି ଆପଣ ରେଜ୍ କରିବେ ଆପଣ ଡିସିସନ ହେଇଗଲା ପରେ ଆପଣ we are not deciding
there is a provision of appeal and revision.
Oh, there is a provision.
No, de-reservation ନାହିଁ sir.
De-reservation
ନାହିଁ sir. ଦେଖା କୋର୍ଟ appeal is making a statement. Let
I may just no he may be wrong so there is no question so
prior to that your lordship 3A mechanical glance the not the below rank of collector does not mean that collector will issue the notice for so
we are not in
the act is the statute
notice invite objection invite କରାଗଲା ଏ petitioners ମାନେ ମଧ୍ୟ objection ଦେଇ ସାରିଲେଣି ଆପଣ ମଧ୍ୟ ତାଙ୍କୁ intimation ଦେଲେଣି ଅମୁକ ତାରିଖରେ ଶୁଣାଣି ହେବ ତେଣୁ we are just saying that let a decision be taken if the petitioners are aggrieved by the decision they will seek appropriate remedy in and all these points we can raise
which is the procedure the procedure modalities is very clear cut that
ଆଉ ଗୋଟେ vital point ଆପଣ just କାହିଁକି ନା ଏଇଟା ଷ୍ଟ୍ରାଇକ୍ କରୁଛି ଆପଣ ଗୋଚର ଲ୍ୟାଣ୍ଡ ଟାକୁ ଯେତେବେଳେ ଡି-ରିଜର୍ଭ କରିବେ ସେତେବେଳେ ଏଇ ତିନିଟା ଗ୍ରାଉଣ୍ଡ ଥିବା ଦରକାର 3A ର 2 ର ABC
ଆଜ୍ଞା
ଗୋଟେ ହଉଛି it is no longer required for the purpose for which it was reserved ମାନେ ଗୋଚର ପାଇଁ ରଖିଥିଲା let us say ଗୋଚର ପାଇଁ ଆଉ ସେଟା ବ୍ୟବହାର ହଉନି can no longer serve the purpose for which it was reserved is in excess of the reasonable requirement for the purpose ଯେତିକି ଦରକାର ତାଠୁ ବେଶୀ ଅଛି whether for the purpose of construction of a stadium a gochar land can be de-reserved ଏଇଟା ଏଇ ତିନିଟା ଭିତରେ ଆସୁଛି କି ସେଟାକୁ ମଧ୍ୟ ଆପଣ କନସିଡର କରିବେ
while report will call for from RI to extent of land is
ମୁଁ କହୁଛି ମାନେ just keep it in mind କାରଣ ଆପଣ ଦିଆ ହେଇଛି ସ୍ପେସିଫିକାଲି ଯେ ଗୋଚର ଲ୍ୟାଣ୍ଡ ଟାକୁ de-reserve କରିପାରିବେ ଏଇ ତିନିଟା ଗ୍ରାଉଣ୍ଡ so if whether for the purpose of stadium you can de-reserve it or not just keep in mind we are disposing on that line keeping all these issues open to him
including your lordship including the power
all right lekon the petition has been filed by the petitioners so and so challenging the notice dated 15/1/2025 issued by Tahsildar Tangi Chaudhar in lease miscase number 1 of 2025, inviting objection from all concerned regarding de-reservation of the land appertaining to Mauja, Mauja, Sordola, Khata number 515, রক্ষিত ইয়েটা কোন আসছে রক্ষিতর আমার ইয়ে ওয়ার্ডটা কোন রিজার্ভ আচ্ছা রিজার্ভ প্লট নাম্বার 1487 and 1479 এরিয়া হচ্ছে 100 acre 1.12 decimal and acre 4.08 decimal and Kisham হচ্ছে গোচর হলো the Land and Counsel for the Land Senior Advocate appearing, Mr. Bhunya, Land Senior Advocate, appearing for the petitioners, argued that the definition of collector in 2A is very clear that it shall include an additional district magistrate. And section 3A of 1962 Act provides that the land can only be de-reserved and the government by notification in the official gazette will authorize an officer not below the rank of a collector to de-reserve any land, which also includes the Gochar land. The Land Council submits that a notification has been issued, notification number 6172-GE GL 3/74 dated 29/1/1974 has been issued by the Revenue Department, wherein it has been specified that the state government has authorized, in view of the powers conferred under Section 3A of the 1962 Act, all the collectors of the state to de-reserve any land which has been reserved under Clause A of Section 3 or any portion thereof within the district under their respective jurisdiction. The Land Senior Advocate placed Rule 4 of Odisha Government Land Settlement Rules 1983, which deals with de-reservation principles, and argued that collector has to invite objection which is to be filed before the concerned Tahsildar, and the same has to be adjudicated after receipt of the objection. But in the case in hand, it seems from Annexure 5 that lease miscase number 1 of 2025 has been initiated by the Tahsildar Tangi Chaudhar, and he has issued the notice dated 15/1/2025 inviting objection which is not in consonance with 1962 rules and 1962 Act and 1983 rules. However, the Land Council further submits that after issuance of such notice, the petitioners have filed their objection under Annexure 6 and the notice has been issued to the petitioners under Annexure 9 to appear, and no final decision has been taken on the objection. Stop. Since the matter is under the active consideration before the Tahsildar Tangi Chaudhar, we at this stage we are not inclined to examine the legal points raised by the London senior advocate challenging the imposed notice after the order is passed by the opposite parties. The petitioners are at liberty to seek appropriate remedy in accordance with law, including raising the points which are taken in this writ petition. It is expected that Tahsildar Tangi Chaudhar, opposite party number 3, yes,
That 4-3 that the representation has been considered. Now the record I have received.
well, it has been considered. So you communicate with them. Why are you not communicating?
In their presence, in presence of some petition, it has mentioned date of hearing 4/3/25. In presence of the some petition.
order dakila pare anigin
that record at least I may be expressed for that.
So, the London Council for the state, however, submitted that on 4/3/2025 itself, the representation, the objection, the hearing has been concluded and order has been passed.
Yes.
That is your case.
Yes, this is the
And in the order, the order has been passed by the Deputy Collector, Revenue Collectorate Cuttack. There are four lecture the other. So and so in the order dated so and so attached to the case record, so and so. Press test map, so and so, so and so, so and so. Tahsildar has mentioned the order as well as the field vision. In returning the deviation, I am directed to request you to verify the matter.
The proposal.
Make a final.
Consider matter immediate for
No, matter is
proposal. Given the proposal.
This is not disposed of. This is pending.
He has given the proposal.
Proposal again re-examination.
Tahsildar kouchen to make a final order narrating so and so.
4 representation pare aur seta patheise the re-examination.
Submits that the Deputy Collector Revenue Collectorate Cuttack has also submitted a proposal before the Tahsildar Tangi Chaudhar in returning the de-reservation case number 1 of 2025 to make a final order narrating all the details with modified trace map and resubmit the case record through Sub-Collector Cuttack for taking action at the end. You give a copy to the Land Council. In view of such letter, it is apparent that the matter is still sub judice before the Tahsildar Tangi Chaudhar. It is expected that the Tahsildar Tangi Chaudhar shall consider the objection filed in connection in pursuance to the notice under annexure. Notice ta?
The notice annexure 5.
Notice dated 15/1/2025. And
further notice the annexure 9, sir.
And further notice under annexure 9 giving opportunity of hearing to the parties and communicate the decision to them in accordance with the law. Accordingly, the writ petition is disposed of. आर गोटे कॉपी रखिए आउ तांको गोटे कॉपी दे देबो है ना बाकी फाइल करे देबो से ठीक है
Pardon to make a mention, my lord. One CRLA number 1015 of 2023, my lord. My lord had called for instruction to take to know how many incidents are there, my lord. And my lord had fixed a date on 17th March, my lord. Till now, it is not.
Give it.
Supplemental list, item number 1.
Imprisonment for life and I know to 30,000. For the trial court record. Record may be there in the connected states.
The connected gentleman PCL was called for on 18th
Who has filed this JCRL 29?
The co-convicted Deepak and Sunil.
How many persons face trial? JCRL has been filed by two persons, Deepak Singh and Sunil. So they are not the appellants here in this criminal appeal.
No.
Right. In that JCRL record has been received.
What was called for on 18th, 2020. Number 1.
Okay. Since it appears that it has JCRL number 29 of 2025, which has been filed by Deepak Singh and Sunil Gowda. Trial court record has been called for as per order dated 18/3/2025. If the same has not been received, then trial court record be called for. And the interim applications, if the trial court record has been received, the interim applications for bail and stay realization of fine be placed for consideration. Otherwise, it will be placed after receipt of the trial court record. Same connected matter emergency here, and this matter will be listed with 394 and JCRLA number 29 of 2020. Connected matter means Luxembourg. IA number 8 of liquidity. It is allowed since the trial court judgment has been filed in CRLA number 393 of 2025. Allowed is. Let them also take instruction related to you collect the that deposition copies you supplied to the land council. I will supply by tomorrow. The land Let them also get the instruction. Yes, the land council for the state shall obtain instruction relating to the criminal antecedent, if any, against the appellant. Yes, and the period of detention. Also the period of detention must be there in that. In the judgment, it's there. Judgment is there, so not necessary. That is. First item to देखिए 393 रे judgment लिखा है period of detention Date of plea class 1 2. কথা से जो फॉर्मेट लिखा है नहीं अच्छा ये कस्टोडियल सर्टिफिकेट नहीं नेक्स्ट
Item 2.
Last question, last order and levels. The booklet of the apply number 1 that is in the colors.
What do you want now?
IA number 98 by 25 colors is
application.
Yes, colors. The file was opinion 1 and 2 colors.
How many appellants are there?
3 appellants are there. The lordship was pleased to grant the bail to appellant number 3 with order dated 27/11/2024.
27/11/2024.
It is person's first trial. Out of 4 acquitted and 4 convicted.
Wait. So it appears that so far as the assault on the deceased is concerned, there is no allegation against that appellant number 3, whom we granted bail. You took into consideration the evidence of the eyewitness PW1, and PW1 stated that that appellant number 3 assaulted PW19 by means of a sword, as a result of which intestine came out. But PW19 himself has not stated that the petitioner dealt any sword blow to him. Rather stated that accused Robbie Doley threw a bomb which hit him, and medical report also does not indicate that his intestine came out. So that was the reason for grant of bail to appellant number 3. So whether you stand on the same footing?
Not exactly same footing, Lordship.
So he might have assaulted the deceased. That man who has been granted bail, he has not touched the deceased.
Yes, Lordship.
Appellant number 1 and 2 did the bombing itself. That resulted in the death of the deceased.
That is the evidence of PW?
Eyewitness? Eyewitness 2, 3, 4, 5, 7, 11, 18.
PW 2, 3.
Yes, sir. 2, 3, 4, 5, 7, 11. You'll show 1 also. 1, 13, 14, 17.
All of them have stated
18.
that.
All of them.
Lordship, PW1 eyewitness, Lordship will examine that, and para 12 of the judgment, Lordship, page 39, Lordship, can have once. The deceased succumbed to injury in view of the bomb throwing by the appellant number 2, Lordship.
Come to PW1, let us see it.
Lordship.
PW1 is one Oppi Behra.
Lordship.
She is the informant. Informant and injured both.
So
page 154 of the paper.
No, पढ़ुनांती कोटा दी यमन overtax asla I raised alarm for help so and so appeared natural brothers bala accordingly Robby called the accordingly Ganga Dole identified so and so appeared in
Can I
the
place
ये जो relevant portion टा कहते हैं
yes, sir. So paragraph 2, 4,
No,
7, 8.
पूरा
May I place it?
पूरा से line
Wow.
Renu to be accordingly the said lady accused at the second page Rashi
Second page.
brought a Dean Diva and supplied 3 bombs to accused Robby,
who is her husband, and soon thereafter they accused Robby
called bombs at my brother Pawan Behera. As a result of which Pawan Behera is the deceased in this case.
No, my lord, the injured.
This is a Sachi Parida.
Asha.
There are 5 injured persons and one is deceased.
No,
He is one of the injured witness.
He's one of the injured.
Deceased को किए deceased ना कौन पहले?
Sachi Parida.
Sachi Parida, your lordship, second page.
Sachi Parida.
PW1 deposition to paragraph 2 last 3 lines. The female accused Renu drew a bomb from open coated of one bottle, as a result of which Sachi Parida lost his left leg. And the Sachi Parida is the deceased, your lordship.
So all the witnesses have stated
that both the appellants, the present appellants, appellant number 1 and they hurled the bomb and assaulted all of the injured persons. And
no,
out
but
of
so
which,
far as the deceased is concerned,
yes,
Specific against Renu.
that is specific against that Renu.
Minors.
So
No, we are coming. Yes, you say that about this 149 or 34, that's a different matter. No, we just come to know that whether this is consistent or not. That all the eyewitnesses have stated that it was the female accused Renu who threw the bomb, as a result of which the deceased lost his left leg.
Both the appellant, present appellant, appellant number 1 and 2, both hurled a bomb. The 2 bombs, there are thrice, there probably, there are...
For which other sustained injuries.
Other sustained injuries, Your Lordship.
Right.
May I place the relevant portion of the PW?
PW?
PW 458. I'll place with PW 45.
You want to PW 4?
4.
Yeah. According to him, who threw the bomb to the deceased? According to PW 4.
Both, Your Lordship. Appellant number 1 and 2.
Deceased कथा कौन तू? Deceased होची सची.
Sachi Parida.
वो लाइन ने लिखा है सची परिडा.
Yes, sir. This is the lady accused, Your Lordship.
The lady accused thereafter supplied bomb
She supplied the Team bomb to the
accused Robby hurled bomb to PW1. Same jinso.
Same.
PW2 also says same thing.
Same.
2 incidents.
PW2 at the end. PW2.
5 also says the
Lady
same thing.
accused hand over the tin diva to Robby
PW2 says,
and Robby
in the meantime,
bomb to all accused persons.
In the meantime, lady accused Renu went away from the spot and threw another bomb on the remaining open courtyard of
Even
one.
the PW5 says that due to the explosion of another bomb by the lady accused.
It means that the person of all the eyewitnesses, that so far as the deceased is concerned, on account of throwing of bombs by that lady accused, he sustained injuries on the left legs.
That was severe from
and lost one leg. But so far as this
appellant
Robby is concerned, that was the bomb was supplied to him by that lady accused, and he threw the bombs, for which a number of persons sustained injuries. So now, in this jail criminal appeal, he has filed the bail application for whom?
Both
the
their husband and wife.
Just a minute.
Rabindranath Dole and appellant number 1 and 2.
So Robby जो मानको bomb throw करथिला, सेमानकर nature of injuries कौन?
May I place the PW23 is the doctor?
No, the PM doctor की.
Not examiner loss.
No, PW 23.
PW 23
20.
No malus.
I'll show the injury sustained by the injured as well as the may please. By 8/3/2013, when I was working as casualty medical officer at Sub-Divisional Hospital, Banki, the same day the police requisition, I examined one Pawan Bera. Pawan Bera is one of the injured. Whereof so and so, and found the following injuries on his person: one bleeding, lacerated injury of size 3x2 over vault of skull, laceration and total turn of left ear size of 2x2, lacerated wound with bony deformity covering total arm and left elbow joint, lacerated 2x1 over the side of forehead, and laceration with surrounding abrasion of skin and blackish discoloration of 4x1 over left chest. The opinion regarding the nature of injuries could not be given pending further radiology examination and CT scan of the patient, who was transferred to SCB MCH Cuttack. Then paragraph 3, I'll place Fellowship. The same day on 8:15 a.m., I also examined one Brahmara Behera of so and so and found the following injuries on his person: lacerated wound with bony deformity size 3x3 into 10 cm below the right elbow, lacerated wound with the gunpowder smell 2x2 on medial side of the right thigh, lacerated wound of 1x1 size of the right middle finger. Yellowship. Then paragraph 5. Did the examination of one Sachiprada with the deceased this case.
Yes.
Yes. I won't be placing this report because he has already died and autopsy reports are there and PM reports are there. Then paragraph 6, Fellowship. It is regarding one Basanta Behra who is injured. One incise wound of 7x7 covering left face, neck and chest. Amputation of left penile with sharp border of size 3x3 and lacerated wound of
What about the criminal antecedents?
I'll get the criminal antecedents. Because this is out of a political rivalry.
No, it's all right.
Yes.
One is about the criminal antecedent.
Yes.
The other is about the period of detention. So,
detention loss 12 years. Detention loss since 8/3/2013.
How do you get it from that? Where from you got it?
Charge sheet loss.
Charge sheet रे तापर bail जाई ना दिसे.
No malus.
केम जानले? आपण कस्टडी सर्टिफिकेट टा आणंतु आउ ये टा आणंतु जो criminal antecedent. IA number 98 of 2025. This is an application for bail filed by appellants number 1 and 2, namely Ravindranath Dalai and Renubala Rao. Let the Land and Council for the state produce the custody certificate of both the appellants to also obtain instruction regarding criminal antecedents, if any, against the two appellants. Put of this matter. 5 तारीख का कुछ नहीं है 12 May 2025. EA and custody certificate. Yes.
Item 3.
Petition, I am entering appeals, my lord. Shall I submit, my lord?
How many appellants are there?
Only sole appellant, my lord.
Sole appellants.
Yes, my lord.
Just a minute. Let us see the judgment. Damburudhar Maji. He faced trial under 302. Bail copy. So prisoner's petition at flag Z to engage you instead of Mr. Pratikant Mahapatra. Renama filed by Swanlu. So what order we passed on the last date? No, she has been informed that prisoner's petition has been sent requesting engagement Swan. And she has also filed Okalatnamasha. Okalatnama अपन फाइल कर दीजिए
ये कॉपी का
ठीक है हाँ ଆପଣଙ୍କର आईए जोटा फाइल करछन्ती केते नंबर आईए
97.
97 सी आगुर जोटा फाइल करछन सेटा नॉट प्रेस कर दउछु देखन the peruse the prisoner's petition at Flag's date for engagement of advocate C.Kasturi as his advocate. In place of the earlier engaged counsel, Mr. Ratikant Mahapatra, advocate. Srimati Sri Kasturi has already filed Wakalatnama, which is accepted. The name of Mr. Ratikant Mahapatra and his associate shall not be reflected in the cause list henceforth. IA number 62 of 2025 is an application for bail. Land counsel for the appellant submits that since she has filed a fresh bail application, that is IN number 97 of 2025, she does not want to face this application. Accordingly, IA 62 of 2025 not face. And 97 of 25 copy upon the please give him a copy. Let the land counsel 97 elections. Let the land counsel for the appellant supply copy of the receipt. I just supplied the copy of the interim application to the land counsel for the state in court. So this JCRLA, you have the trial court record is here and paperwork you have received. Yes. So what is the case of the, how many years you are in custody?
This is my lord. There is no enmity, there is no intention, there is no quarrel, my lord. All of a sudden, my lord,
No, we are asking about your period of detention.
Period of detention, my lord, nearly 12 years, my lord. 11 and a half years.
How you get it that, where from you got it? Because during trial it appears that you are never released on bail. And okay, accused is produced. All the orders indicates that you are in jail custody. Trial court record. And judgment was pronounced on 2/8/2016. तापर आपण हाई कोर्ट रु बेल जाइना
No, my lord.
ठीक तो अच्छा एटा 54
My lord, PW7, the wife of the deceased, my lord.
so just deceased ro na kono Raju Maji Domburu sir Robby Maji na
Yes, sir.
Robby Maji hochi deceased.
Yes, my lord.
So please come to paragraph number 2 of the judgment.
The case of the prosecution is that on 26/10/2013 at about 3 p.m., while the deceased, aged about 62 years, was standing on the road near his house, the accused suddenly went there and dealt him kicks and blows. He also chased the deceased. The witnesses present at the spot tried to rescue the deceased, but the accused forcibly dragged him towards his house and also assaulted him by means of brick khappara on his head and face, as a result of which the deceased died at the spot. The accused tried to escape from the spot, but the witnesses caught hold of him. The accused was also detained by them. The informant came to know.
Who are the eyewitnesses to the occurrence?
Hello?
Eyewitness के अचानक
157, 8 and 9.
1, 5,
PW7 and 5
7, 8, 9. पांच जन eyewitness.
That is recorded in para 5 re.
Who is the doctor who conducted PM?
16.
PW16.
So no weapon like that has been used.
No.
It is only kicks and fist blows. तापरे पत्थर. अच्छा.
पत्थर नहीं.
ସେଇଟା ବି କହ.
Multiple small abrasion over the left shoulder, upper sternum, and in front of the neck. Brain hemorrhage
Cause of death due to cerebral vascular injury.
The doctor says, my lord, I did not notice any stain of blood on these articles. I did not
Cerebral injury, normally blood is not cerebral injury inside.
So, no, the main ground is about the period of detention. 12 years, and as it appears, he was a young boy at that time. And what is the motive? Why he assaulted that old man?
motive, no quarrel, no intention, no.
Anybody
My
has
lord,
stated anything?
PW7, my lord, the wife of the deceased, my lord, says.
Yes, what he has stated.
She says, my lord,
On the relevant date at about 3 p.m., accused called my husband from the house. I, along with deceased, came out the house. As soon as we came out, accused dragged my husband towards the house of Bikram Maji by dealing kicks in front of house of Bikram Maji, the PW6. Accused again dealt kicks and fist blows on my husband. When I raised Halla, Astima Maji, PW5, arrived there and we tried to interfere but failed. Accused dealt blow to the head of my husband by means of a bricks. Again the dealt blows on the face of the wife.
ପ୍ରଥମେ ହଉଛି kick and fist blows, ତାପରେ ହଉଛି brick ରେ ଆଉ ଖପରା. He died on the same day.
On the spot.
in cross-examination, my lord, the wife of the deceased says, my lord, it is not a factor.
Final form indicates that he was taken into custody on 28/10/2023. 2013 ସରି 18/10/2013 ମାନେ 11 ବର୍ଷ 6 ମାସ ପାଖାପାଖି 6 ମାସ 5 ମାସ କମ୍ପ୍ଲିଟ ହେଇଗଲା। Counsel for the state. The land counsel for the petitioner submit that the petition was taken into judicial custody since in judicial custody since 28/10/2013. He further submits that from the evidence of the eyewitnesses, that is PWs 1, 5, 7, 8, and 9, it appears that the petitioner first gave kick and fist blows to the deceased Ravi Maji and then assaulted him by means of bricks and copra. And no motive behind the commission of the crime has been proved by the prosecution. And even though paper book has already been prepared, but there is no chance of early hearing. Therefore, the bail application may be favorably considered. Land counsel for the state place the evidence of the eyewitnesses to also the evidence of the doctor PW16 was opined that the cause of death was due to cerebrovascular injury. Considering the submission made by the Land counsel for the respective parties, the period of detention of the petitioner in judicial custody, the nature of evidence adduced, the period of detention of the petitioner in judicial custody, absence of any chance of early hearing, we are inclined to release the petitioner on bail allowed.
Item 4.
Order dated 27/3/25 में गला glass. But there is
You just now, the Land Council for the appellant supplied the deposition copies of the witnesses to the Land Council for the state in court today, who seeks for an adjournment to go through the deposition copies put of this matter next week.
Item 5.
Yes, Mandakini Panda.
There is a nothing at premature release about
Regional petition ଦେଇଥିଲେ ତାଦେହରେ ମୋତେ वकालतनामा ପଠେଇ ନାହାନ୍ତି
No, ଠିକ ଅଛି. Report of premature release of the petitioner. Sorry, ପଳେଇଲାଣି?
ହଁ 16 ବୋଧେ ପଳେଇଲେଣି ତାର ରିପୋର୍ଟ ଗୋଟେ
Being an expert person, ସରିଗଲାଣି ତ ଭାବୁଛି ଲେଖନ୍ତୁ peruse the report on premature release of the appellant at flag B, which indicates that the petitioner, that the appellant has been released from jail custody on 16/4/2025, being on expired portion of the sentence remitted by special order of the government. In view of such letter dated of the senior superintendent circle jail, CORAM dated 17/4/2025. The JCRLA is disposed of. Yes. Next.
Item 6.
Application for revival.
Case manager attend had petition for bail and last application lawsuit directed to the state government to submit the report of the criminal antecedent and
Yes, madam. I have in the criminal antecedents. So for the medical ground is concerned, that report has not been complete.
ଠିକ ଅଛି ଆପଣ ବହୁତ ସମୟ ଦିଆହେଇଗଲା ଆପଣ ଆଣିଲେନି ଠିକ ଅଛି we are granting you are not produced you cannot the first order was passed on 28/2/2025, then 11/3/2025, then 18/3/25, then 26/3/25, and lastly on 8/4/2025, and on that day also last chance was given. So you are a local man or outsider?
I'm a local.
So look, IN number so and so. This is an application for interim bail on the ground of element of the parents of the petitioner. Father of the petitioner and a parent. Bapar deog na kon Bapa Maj. Medical documents have been annexed to the interim application. When the matter was taken up for the first time on 28/2/2025, we asked the Land Council for the state to obtain instruction on the interim application, including the authenticity of the medical documents. Thereafter, the case has been stayed on 11/3/25, 18/3/2025, 26/3/2025, and last time on 8/4/2025, wherein we granted time to the state as last chance. Today, the Land Council for the state has produced the written instruction dated 8/4/2025 from IIC Nilagiri Police Station, wherein it is mentioned that the petitioner is not involved in any criminal case and no adverse has been reported at Nilagiri Police Station during the period of his interim bail. The Land Council for the state, however, submits that he has not yet received the instruction on the health condition of the parents of the petitioner, so also the authenticity of the medical documents, as was ordered on 28/2/2025. Considering the submission made by the Land Council for the respective parties, since in spite of grant of adjournments, number of occasions to the Land Council for the state, no instruction has been received on the interim application regarding the element of the parents, also the authenticity of the medical documents. We are inclined to grant interim bail to the petitioner for a period of 1 month from the date of release, subject to condition that while on interim bail, he shall not indulge in any criminal activities and shall not try to come in contact with the family members of the deceased. Violation of any terms and conditions shall entail cancellation of the interim bail order. The inspector in charge of Nilagiri Police Station shall keep a close watch over the activities of the petitioner while on interim bail. Matter will be stayed in the last week of June 2025. The Land Council for the appellant shall produce the surrender certificate. Yes, next.
I kindly grant me 2 months because of
15 दिन कम ही देते चार मास्टर को 15 दिन करती. Yes, next.
Item 7.
Next.
We are sending the letter on 15/4/25 regarding the notice of the victim, my lord.
Yes.
The report has not come.
What is the offense? Why notice was
6.
376(3) is there. Oxo is also there. An application for bail letter, 5/5/2025. 2025. Yes.
Item 8.
The appeal is in file still the judgment that is 27/7/2016.
You are moving this CRLA 1042. And what about 1041?
That is the case 41 also.
You are moving these two bail
Yes,
applications.
so Gadas and Godada.
And Mr. Mahanti, you are there in that.
Prayed for interim bail, Lordship. And on the last occasion, report was called for right order dated 11/12/2024.
Yes, 11/12.
It has come.
On the ground of the element of the
Element.
mother of the petitioner.
Yes, Mr.
Articulous, other old age diseases, medical documents have been filed, authenticity of the medical documents and the instruction of the interim appeals. So what will be?
Medical documents are genuine, but other persons are there, they can take care of the matter. That is all.
So outside the lawsuits custody, 10/7/2017. No eyewitness is there in it.
Just a minute.
I think the witness have already been examined, prosecution, putting the prosecution evidence, and there are the vital evidence.
No, why are you seeking for interim bail? I couldn't follow. Your bail application was rejected on merit earlier or what? Then you can apply for bail during in pendency of this. So why have you interim bail? What has been used? It presupposes that somebody you are asking for a temporary period, not till the disposal of the appeal.
Ujjain, Madhya Pradesh.
So address verification ହେଇଗଲା କଣ ହେଲା ଠିକ ଅଛି
ଆଜ୍ଞା is correct.
and what are the allegation against him?
202, 97, and 201.
Eyewitnesses are there.
No idea.
Then how the conviction has been based on what evidence?
Provincial lordships. 8 your lordship. Prosecution evidence PW8.
No, whatever you have stated, it means that on the basis of circumstantial evidence you are found guilty. What are the circumstances against you?
Your lordship, taken the onion from Ujjain, sold it at Bhubaneswar, Guinea, and thereafter taken
34,500, and whereas the dead body was found at Decanal and Velocity.
So you are in the company of the deceased. You are a truck driver or what?
Deceased was the truck driver.
Oh, deceased was truck driver. You are doing what? Helper?
Helper, yes.
Acha. So both of you have come to Odisha.
Come to Odisha.
From Ujjain.
Taken onion and sold it at Bhubaneswar.
No, it's all right. In a truck, you and the deceased was the driver came from Ujjain carrying onion. Then you unloaded the onion. Okay, received 34,500 towards the sale price. Then both of you left. Thereafter, the dead body was found. The deceased was found where?
The dead body found near the hatchery.
All right. And the truck was also there.
Truck was also there.
But you were not there.
No. After 10 months, the deceased was found.
After 10 months?
Yes.
Dead body was found?
Not sure.
You were found up. You were not there. You were arrested after 10 months.
10 months.
So, what is your explanation when the deceased left with you in the very truck and the dead body was found on the way to Ujjain, and it was a case of homicidal death, and that cash which was received, that was also not there?
That's what it is.
So he has applied that 106 Evidence Act, that you are supposed to discharge your burden of proof that how he died. What you have stated in your accused statement? ସବୁ ମିଛ କଥା ନା କିଛି କହିଛନ୍ତି? ସବୁ ନାଇଁ ନାଇଁ ମାନେ ଇଏ ଡିସିଜ୍ଡ ବି ଯାଇଥିଲା ଆପଣଙ୍କ ସାଙ୍ଗରେ ସେଇଟାକୁ ବି କହୁଛନ୍ତି ନେଇ ଯାଆନ୍ତା ସବୁ ନେଇ ଯାଆନ୍ତା ଟୁ ବାତ ଏଇଆ କହୁଛନ୍ତି मालूम नहीं झूठ बात मुझे फंसाया गया है. So who had was stated that this man left in that truck with the deceased? That is Fiddle.
Was he was still kept in the abandoned
PW7.
abandoned.
किए
Minus like the ownership.
PW7.
PW7.
In the morning hour, the accused driver कौन पूछी और deceased कौन driver ଥିଲା? नहीं accused लक्ष्मण पड़े ଆପଣ ଆମକୁ ପଚାରିଲ ନା ଯେ ଡ୍ରାଇଭର କିଏ ଥିଲା? ଡ୍ରାଇଭର ହଉଛି deceased, କିନ୍ତୁ ଏଠି କଣ ଲେଖା ହେଇଛି PW7 ରେ in the morning hour the accused driver came with a truck and I instructed him to park the truck at a little distance. PW7 no? हाँ PW7 हଉଛି ମାନସ ନାୟକ.
Minus like.
I know accused Lakshman Road standing in the road 10 to 12. I was working as a Pirozbar restaurant. On a day in the morning hour, the accused driver came. So it's not that the deceased was the driver. The accused was the driver. Came in a truck. I instructed him to park the truck at a little distance so that so and so. The accused was alone in the truck. Thereafter, he parked the vehicle at a little distance from the restaurant, went away. In the evening, so he has not stated anything about the deceased. No, yes. In the evening, police came, informed that somebody has been murdered in the truck. 7:12 after the said incident, I was asked by the police to identify the accused. And accordingly, I identified the accused in the jail. Deceased, ये कहला जे accused होची गोटे ड्राइवर ट्रक रो सी आसिला आसिकिनी ता गाड़ी को आमे कहलु जे तमे टिके दूरे किनी रख रेस्टोरेंट ता जेमती ब्लॉक होबनी आ accused एकुटिया थिला ट्रक. So where is the evidence that the deceased was there in the truck? No, that. तो किए कहिची से दी जण जाक से ट्रक रे थिले
Last scene.
Last scene को evidence टा को आनिया बोले somebody has to say ना जे ସେମାନେ ଦି ଜଣ ଯାକ ଥିଲେ ଦି ଜଣ ଯାକ ଟ୍ରକ୍ ରେ ଗଲେ ଟ୍ରକ୍ ଓନର ଆଉ ଏକୁଟିଆ ଥିଲା ତ last scene କେମିତି ହବ? Last scene in the company of the deceased, who has stated that? Yes, land counsel.
No, your lordship, nobody can see this.
କେହି କହିନାହାନ୍ତି ଆପଣ deceased ଏକାଠି ଆସିଥିଲେ ଏକାଠି ଗଲେ ବୋଲି?
Generally be here. Even if the family members of the deceased, they have not stated this.
Conviction ଟା କେମିତି ହେଲା ତ?
The people 9, 10 and 11 and 13.
Wait. Come to PW9. PW9 evidence আসলে
9 and 14.
Read it out. PW9. Are you having the copy of this? Deposition of PW9. Read it out.
The deceased in the case, namely Prakash Pawar, is my brother. He was driving a truck during registration of counsel. Known accused Lakshman Bodeda. He was the nephew in that truck. On 14/2016, the deceased, along with the accused Lakshman Bodeda, a truck onion in that truck from Indore Ujjain to Bhubaneswar on 17/9/2016. The deceased unloaded the onions at Bhubaneswar. After unloading the onion, he got rupees 34,000 price of onions or as regards receipt of rupees 34,000. Rakesh Pawar as
information ବିଷୟରେ କହୁଛି PW9 that is given to one Rakesh Pawar. So he has not heard, this PW9 has not heard from the deceased. So Rakesh Pawar को अपन examine करना थी. Evidence here say wait. Now see whether Rakesh Pawar has been Raju Pawar. No, Raju. Rakesh Pawar.
We have also examined.
PW10 टा important देखो.
I am the owner of the truck during the of so and so. I know the deceased Prakash Pawar. He was related to me as my nephew, brother's son. He was driving my aforesaid truck. I know the accused in the dock. He was working as a helper in the truck. 2025 days prior to the occurrence. In 14/2016, the deceased and this accused left for Bhubaneswar in their truck, loading onions for delivery at Bhubaneswar. On 17/9/2016, they unloaded onions from that truck, and after unloading same night, Rakesh telephoned me saying that the accused was threatening and insisting him to bring liquor. In the same night, the accused killing the deceased and
this evidence ଆସିଲେ threat ଆସୁଛି. Last scene ବି ଆସୁନି ଯେ ଟ୍ରକ୍ ରେ ଏକାଠି ଗଲେ ବୋଲି କରାଯାଏ ଯେ ଅନଲୋଡ କଲା ପରେ ସେ ଖାଲି ଧମକ ଦଉଥିଲା ବୋଲି ଆସୁ. On 14 the deceased and this accused left for Bhubaneswar in that truck loading onions for delivery at Bhubaneswar.
ଠିକ ଅଛି ଯାଇଥିଲା
ଆଜ୍ଞା
ସେ ଯାଇଥିଲା କଣ ନାହିଁ ଯାଇଥିଲା ଅନଲୋଡ ହେଲା ତାପରେ ସବ ଦି ଜଣ ଯାକ ଏକାଠି ପୁଣି ବ୍ୟାକ୍ କରୁଥିଲେ ଉଜ୍ଜୟିନକୁ ସେ ଏଭିଡେନ୍ସ କିଏ ଅଛି?
Getting the information from ढेंकानाल police, Wilson and my nephew Nanulal came to the ढेंकानाल police station, seized the documents of my truck on my production and prepared
ସେମ୍ ଜିନିଷ କହୁନାହାନ୍ତି ଯେ ଦି ଜଣ ଯାକ ଏକାଠି ସାଙ୍ଗ ହେଇ ଗଲେ 10 ଆଉ 11 ରୁ ଆସୁନି ଦି ଜଣ ଯାକ ବ୍ୟାକ୍ କଲେ ସେମ୍ ଟ୍ରକରେ
Evening 6 P99 Nanulal Power, brother of the deceased.
Yes.
And P10 Bonorilal Power, the owner of the truck. And P11 Akhilesh Power, P13 Gulshan Power, and P14 Raju Omkar alias Power. They have not examined your situation.
Yeah, Gulshan Power was examined. That is PW13.
But not specials. This the petitioner
So you evidence you last thing out main apart from the absconding ଆଉ ସେ ଯୋଉ ଧମକ ଦେଇଥିଲା ଟଙ୍କା ଡିମାଣ୍ଡ କରୁଥିଲା କିନ୍ତୁ ଲାଷ୍ଟ ସିନ୍ ଏଭିଡେନ୍ସ ରେ ଆପଣଙ୍କର ସ୍ପେସିଫିକାଲି କେହି କହିନାହାନ୍ତି ଯେ ଯୋଉ ଟଙ୍କା ନେଲା ପରେ ଉଜ୍ଜୟିନକୁ ଦି ଜଣ ଯାକ ସେଇ ଟ୍ରକ ରେ ଫେରିଲେ ଖାଲି ଏଭିଡେନ୍ସ ଆସୁଛି ଯେ ସିଏ ତାକୁ କହିଥିଲା ଫୋନରେ ଯେ ମତେ ଆପଲାଣ୍ଟ ଟଙ୍କା ମାଗୁଛି ଆଉ ଧମକ ଦଉଛି
PW14 again confessed PW14. Yes. The accused confessed to have killed the deceased out of anger with a wheel of span when the deceased did not oblige him to part.
It's recovered this weapon of offense.
For taking liquor while returning from Bhubaneswar and threw the dead bodies of the deceased in ढेंकानाल jungle. He also confessed to have concealed the weapon of offense inside the cabin.
Please come to this paragraph number 5 of PW14. ସେଠି ଯଦିଓ କହିଦେଲା paragraph 2 ରେ
I derived the
accused confessed before me, but I derived the knowledge of the incident from so and so, not from the accused. Sustain କରିବେ conviction 302 ରେ କେତେ ବର୍ଷ ରହିଲେଣି ଆପଣ?
10 ବର୍ଷ 7 ମାସ 10/7/2017 କରିଥିଲି।
ହଁ ଜଜମେଣ୍ଟ ରେ ଲେଖା ହେଇଛି ଆପଣ କେତେ କେବେ ରହିଲେଣି?
10/7/2017
10/7 ଫାଇନାଲ ବନ୍ଦ କରିକି
10/7/2017
10/7 ଫାଇନାଲ ବନ୍ଦ ଲେଖା ହେଇଛି
8/7/2017
You are Lakshman Budade. You are not released on bail during trial. Accused produced in custody. All right, take down. Heard the learning counsel for the petitioner, learning counsel for the state. The learning counsel for the petitioner submits that the petitioner is in judicial custody since 8/7/2017 and the case is based on circumstantial evidence. And though it is the case of the prosecution that the appellant was the helper in the truck in which the deceased was the driver, and they came together in a truck with onion and unloaded the same. Who unload kale? At Bhubaneswar, and the deceased received some amount towards the cost of the onion and transportation charges. And thereafter, the appellant asked for some money to the deceased, and since the deceased didn't pay the same, freight was given by the petitioner to the deceased, but there is no evidence on record that the petitioner and the deceased left Bhubaneswar
in the same trough towards Ujjain, and therefore, in absence of the petitioner in the company of the deceased, the other evidence available on record are not that clinching to sustain the charge under Section 302 IPC, and there are good chances of success. Balance of convenience is in favor of the petitioner. Therefore, the bail application may be favorably considered. State oppose the prayer for bail and place the evidence of PW 10 and PW 11. And
9, 10. 9, 10, 13.
9, 10 and 13. 9, 10 and 13. Considering the submission made by the learning council for the respective parties, absence of any direct evidence, nature of circumstantial evidence on record, period of detention of the petitioner in judicial custody, and absence of any chance of early hearing, we are inclined to release the petitioner on bail allowed.
Item 10.
Last Union is also directed to take instruction on age and antecedent of the offenders.
Notice the letter was sent, another small date may be given. On 15, 16 for 2000, we have asked for the, since the, about the health condition.
See, the age has been given to be Nalsar जो guideline अच्छी years of above. So,
ठीक है तो इधर trial होता था 80 years तक. हाँ, 19 बेलू 80 already है.
No, ଆମେ ସେଇଥିପାଇଁ କହିଥିଲୁ ଯେ ତାର instruction about age aspect, our health condition,
both.
Apart from that, the criminal antecedent. So the instruction has come that in such cases, the it is to be liberal attitude is to be adopted. Terminal illness ଆଉ ଏ ଯୋଉମାନଙ୍କୁ 70 ବର୍ଷରୁ ଅଧିକା ହେଇଗଲାଣି ତ ଆପଣ ତାକୁ ଗଡେଇଲେ ହବ କି?
ନାଇଁ 16th ଯାଇଥିଲି 7 days issue, not another 7.
All right. IN number 1 is an application for bail. Land counsel for the petition state 6 adjournment till next week to obtain instruction as per the order dated 9/4/2025. Put up this matter next week.
What is the name of the accused?
Balaram Bari.
Balaram Bari.
Charge sheet देखी दो सेट अप से की तो
Health condition is very serious.
Judgment भी लिखा है इसका ये stuff.
What instruction did you get? You can't see the
Health condition is very serious.
Health
During
condition.
trial,
70.
80 लिखा है जी 80 years.
Charge sheet लिखा है.
इस ट्रायल कोर्ट रिकॉर्ड हुआ था.
I have talked with
Date and year of birth लिखा है. छोड़ा ही गया छोड़ा ही. And accused statement रे कितने एज कोई चीज है?
80 को.
80 years कोई चीज. तो टिक इंस्ट्रक्शन 80 वर्ष ट्रायल कोर्ट निजे कहउछन्ती 80 वर्ष मध्ये लिखिछन्ती.
I have talked with the conducting law court on conducting law. He stated me that during trial ସମୟରେ 2-3 ଥର ସେ ପଡିକି admit ହେଇଥିଲା.
ପଡିକି
hospital admit ହେଇଥିଲା.
No, obviously 80 years so we are fixing it to next week. Date देगी 29 तारीख रखिए. 29 4/2025. Yes, next.
Item 11.
Allowed on the interpretation and pregnancy.
All right. The ଏଟା କେତେ ବର୍ଷ ହେଲାଣି ତ pregnant or 31 years. The land council a mention is made on behalf of Nata Lakirian, Mr. Amitabh Tripathi for adjournment. Gote saptah for 1 week. Put up this matter in the week commencing from 5th May 2025. Yes.
Item 12.
made plea, Your Lordship. My Lord, I may be permitted to.
What is this interim bail?
My Lord, I have filed IN number 380 by 2025 only with a prayer, Your Lordship. I may be granted bail for few days. Only I may get made a prayer for
For what purpose? Few days.
My Lord, the petitioner, Your Lordship, he was the only earning member and he has engaged State Defense Counsel. Your Lordship may kindly see, even he could not engage a lawyer for his behalf. And page 10 of the appeal, Your Lordship, that is internal page 2.
Merit bail reject
Again, Your Lordship, earlier on 11/9/2024.
Just a minute.
Order number 3.
Oh, it's a case of double murder. And axe was utilized to assault the deceased person. Postmortem report indicated number of incised wounds. So all these things have been detailedly discussed. So why bail will be granted? We have rejected it.
Your Lordship has observed that after that is the 11/9 last in the last but one paragraph. Your Lordship has observed that I can make a renewal of the prayer after 1 year.
That period has not expired.
I am not praying for regular bail, only Your Lordship for a period of few days because Your Lordship may kindly see since
take instruction on the interim application.
And that they have already.
Lordship, we have already taken instruction. The instruction is at flag D, Your Lordship.
Flag D.
Yes, Your Lordship.
There is no medical necessity of other. That is one thing I have mentioned. But the thing is that
just a minute. Wife is the family members of the patient mental depending on the moral. Yes, certain family members suffering from chronic disease. So nobody is suffering.
No, that I have not also stated.
Sorry. Double murder case. IN number
Since 25/7/2016, I am in custody.
There is an application for interim bail for a period of 3 months. The bail application of the petitioner was rejected in IN number 995 of 2024 as per order dated, taking into account that it's a case of double murder and the role played by the petitioner in assaulting both the deceased by axe as deposed to by the eyewitness. Though some grounds have been taken in this interim application, but the London Council for the state has received instruction from the IIC Sadar Police Station, Balangir, which indicates that the family members of the petitioner are maintaining their livelihood by depending upon the in-laws family, and no family members are suffering from any chronic disease or needs any medical assistance. And
may I pray only for a month?
If the petitioner is
distress condition of the family
released on bail, the opposite party may be revengeful and law and order situation cannot be ruled out. And the deceased family are in state of fear. In view of such report furnished, we are not inclined to grant interim bail to the petitioner. Stands rejected. Next.
Item 13.
Which time?
Meanwhile, we'll serve the deposition copies on the
Deposition copy has been served.
No, not yet.
All right. You are mentioning on behalf of Mr. Dharanidhar Naik. Madam Mishra, Grand Counsel appearing for Mr. Dharanidhar Naik and Senior Advocate submits that she will supply the position copies of the witnesses to the Land Council for the state by next week, and the matter may be taken off 2 weeks after put of this matter after ensuing summer vacation date.
Item 14.
Yes, Mr. Rautray.
No, cancel the order date is 7/4/25.
7/4/25.
Yes, sir. Last order was there.
So no criminal antecedent.
Yes, sir.
So whether your bail application was earlier rejected.
No, first time test found.
And how many years you are in custody?
So during trial, they were on bail. Both appellants were on bail. Magistrate court.
The case under section
302, 201, 120.
Okay, eyewitnesses are there.
No, man.
Then what are the
circumstances? That is last seen together. And
what is the name of the deceased?
That is Krishna Purohit.
Krishna Purohit.
Yes, ma'am.
When the occurrence took place?
On 19/10/13, the deceased was missing. And on 20/10/13, the missing FIR was lodged in the next day. And on 2/11/13, the dead body was recovered.
Who?
From jungle. But at the 27 recovery minute, prior to that, the recovery minute PW3 and that is 23, the police witness minute, they have stated that prior to our arrival, also persons are there at this spot. It is already recovered.
No, 27 Evidence Act, upon kebe arrest legi?
May arrest minute on minute on 4
date of arrest.
Yes, sir. Yes, sir.
2/11/13. 2/11/13. कौन है आपन को इंस्टेंस रे डेड बॉडी टा रिकवर होला
सेतेर से कॉल रिकवर करे पे PW3 and 23 they have stated that before our arrival the other persons were at the spot.
अच्छा,
it is already
the fact has already been discovered
Yes,
which
sir.
cannot be rediscovered. अच्छा ठीक है जी. तो सेटा हो जी किए कोई जन
PW3 and 23 the police witness.
3 and 23
the police witness.
Police witness. गोटे होची लीडिंग टू डिस्कवरी से कौन डेड बॉडी रो कंडीशन केम थिला
डिकम्पोज्ड मतलब कंडीशन
डिकम्पोज्ड. ये तो गोटे लाउ कोन होची
और लास्ट सीन मतलब the PW18 was identified in the court. First time in the court मतलब he is not identified. First time in the court he is identified the appellant that he was person.
चिन्हा लोगों में चिन्हा लोगों जी ना कोई तो आगु कौन दो
ना कोई नहीं. So during court investigation he has not stated anything regarding this petition. First time in the court.
मैंने PW18 evidence बार को Well, I know both the accused standing in the dock.
Yes, sir.
Lady accused is the widow of the deceased. On 19/10/23, I was returning from somewhere. At that time, it was 7:30 p.m. I stopped at Bahal bus stand to take standing at a distance of 20 meters away from me.
Near a white
color mini four-wheeler, which is locally called Chhatta Hathi. Acha. Noticing him, I asked him if he wanted a lift by me, but he refused and informed me that he would return back later on after finishing his work. Acha. At that time, another man was sitting in that white color four-wheeler. On such answer by the deceased, I returned back. 2 days later, I came to know that the deceased was missing. Finally, came to me know that in that aforementioned white color vehicle, which was of Tata ACE make, the said person shifting in that evening only Maharaj has murdered the. Now that Maharaj, whom I had seen in that evening, and so inside the white colored four-wheeler, is none but the present male accused now.
Identified.
Then come the question
In,
paragraph 4.
Paragraph 4 कौन कहला?
At Vedavan bus stand, there is no street light. House of the deceased situates around 50 meters away from the house.
500 meters.
500 meters. After my coming to know about the missing of the deceased, till the hearing about the matter, during that transitional period, I have never informed the police. And in that evening on 19/10/13, I have noticed the deceased near a white color Tata vehicle at Vedavan bus stand. Around 20 to 50 days later to recovery of the dead of the deceased. So far, I remember the police has examined me in this case. During my examination by the police, I had not informed police that I can identify the person who was sitting inside the white color.
So, deposition देला केबे 2/8/2016 रे. केमती सेटा बिलीवेबल हबो? पाखापाखि आपणकर 3 वर्ष पाखापाखि ही जाउछ. गोटा पर्टिकुलर समय पई गोटे कार भितर राति रे जने
Not
कार
only
भितर
this circumstance, other circumstances are there.
How come?
I will explain. My lord, the co-accused, she is Sittu Panda. She is the wife of the deceased. PW6 and PW12, they have stated that there was extramarital relationship between the co-accused Sittu Panda with the present accused Vishwaranjan Gupta. Therefore, there was a quarrel between the deceased and Sittu Panda. On the relevant date, PW6 stated that deceased stated to PW6 that Maharaja called me, I am going to meet with him. The present petitioner is Maharaja, who over phone policy. What a insurance policy. The present deceased was the insurance agent. What a policy ଅଛି ଆସ. ମୁଁ ମହାରାଜା କହୁଛି policy ଅଛି ଆସ. PW6 ସେ କଥା କହିଛି. Then my lord, during investigation, police obtained the CDR, and it is revealed that from the CDR analysis, there was a incoming call from the mobile phone of the accused to the deceased on the relevant date, on which date he was found missing.
Prior to that also, we are talking about
yes, that was
not for the first time. Prior to that, he was talking.
ତା ପୂର୍ବ ଡେଟ୍ରୁ ସେଦିନ ପର୍ଯ୍ୟନ୍ତ ତାର ଯେ CDR analysis ରେ deceased ର କଲ୍ ଆସିଛି accused ପାଖକୁ. Second circumstance, my lord, PW18 stated that ଯେ ମୁଁ ଦେଖିଲି ସେ କଥା ହଉଥିଲା ସେ ଗାଡି ଭିତରେ ବସିକି ଏଇ ମହାରାଜାକୁ ଆଇଡେଣ୍ଟିଫାଇ କଲା କୋର୍ଟରୁ ବିଶ୍ୱରଞ୍ଜନ ଗୁପ୍ତା.
3 ବର୍ଷ ପରେ.
Third circumstance, my lord, leading to discovery. While the police custody, he confessed that he has killed and buried the dead body inside the jungle under earth. And led the police, after digging the earth, the dead body was found, my lord. ମାଟି ଖୋଳିକି ବାହାର କରିଛନ୍ତି.
କଣ କହୁଛନ୍ତି 3 ଆଉ 4 କହୁଛନ୍ତି
3 ଆଉ 3 ଯାଇଥିଲେ.
ନାହିଁ ଯେ ଆପଣଙ୍କର ବା ଏକ୍ସକ୍ଲୁସିଭ ନଲେଜ ନାହିଁ ଯେ ଏଇ ଜାଗାରେ ସେଟା ପୋତା ହେଇଛି. So it was only your exclusive knowledge that the dead body has been under the earth. So the dead body was exhumed after the soil was removed, and so you are having that special knowledge. So how you knew that the dead body is here? So either you have seen somebody was putting the dead body there under the soil, or you yourself have done it. So otherwise, how
that is also
you
not the
knowledge?
evidence of whether I have
No. ଆପଣ explain କରିବେ. ଆପଣଙ୍କ instance ରେ ଗୋଟେ ଜାଗାରୁ ମାଟି ଖୋଳା ହେଇକିନି ଡେଡ୍ ବଡି ଟା ମିଳୁଛି ଏବଂ ଆପଣ ପୋଲିସ ପାଖରେ ଷ୍ଟେଟମେଣ୍ଟ ନେଇକିନି ସେ ଜାଗାକୁ ଯାଉଛନ୍ତି, ସେଇ ଜାଗା ଖୋଳା ହଉଛି, ଡେଡ୍ ବଡି ମିଳୁଛି, ତ ଆପଣ କହିବାକୁ ପଡିବ ଯେ ଆପଣଙ୍କ ନଲେଜ ରେ କେମିତି ଆସିଲା ଯେ ଡେଡ୍ ବଡି ଟା ସେଠି ରହିଛି ବୋଲି.
And fifth circumstance is PW20 doctor. Doctor evidence is better cut.
But the recording offense has not been seized.
Yes, that is
the mobile phone has not been seized.
not a direct evidence.
Yes,
It's a
sir.
case based on circumstantial evidence.
4 number of
And
injuries are there. One is cutthroat.
TW 23, my lord, can you tell me that crossing over paragraph 2, my lord. The same evidence at PW3, my lord.
What about this lady Situ Panda?
Situ Panda is custody convicted.
Huh?
I'm applying for
Yeah, I
Situ
think
Panda.
No, Situ Panda against the kishi nahi.
Situ Panda against ଏତିକି ଅଛି ଯେ there was a frequent quarrel between the
It's the story of the prosecution, my lord. Nothing more than that.
She is the better case for big.
लास्ट सीन थी ना आनार अच्छी
ना
आ इंस्टेंस रे डेड बॉडी मिलना या तो खाली एक्सेप्ट हस्बैंड I was suspected that she is having extramarital relationship
CDR.
with this Vishwaranjan.
CDR ଅଛି
Huh?
CDR analysis ରେ
CDR ସେ କହେଲା କଣ ସେ CDR
ଟେଲିଫୋନ ରେ କଥା
ଖାଲି ମାନେ ଏଟା ହଉଛି ଯେ
participated in the killing.
ସିଏ ତା ସାଙ୍ଗରେ କଥାବାର୍ତ୍ତା ହଉଥିଲା
she has not participated.
ହଁ ଏଇ ସମୟରୁ ଏଇ ସମୟ ଯାଏଁ ସିଏ କଥାବାର୍ତ୍ତା ହେଇଥିଲା.
My lord.
But how and he's a lady.
You move application for bail.
My lord.
How much custody you have?
My lord,
Situ Panda, she was on bail during trial.
my lord.
Yes.
Both are
on bail during.
And my lord, what the story, my lord?
What is custody, period of custody you tell?
Since the date of judgment, he is in custody.
Situ Panda CRL number 841 of 2024. The learning counsel for the petitioner submitted that the petitioner Situ Panda is the widow of the deceased.
My lord.
Gokulananda Purohit, na?
Purohit.
Na
My lord.
Goti
Krishna Purohit.
And though it is and she was on bail during trial, and there is no direct evidence in the case. The case is based on circumstantial evidence, and whatever the circumstances are available on record that is against the co-accused Vishwaranjan Gupta, who is an appellant in CRLA number 723 of 2024. She further submits that on suspicion, the petitioner has been implicated in the crime, and she has got good chances of success in the case, and balance of convenience is in her favor, and therefore the bail application may be favorably considered. Learned counsel for the state opposed the prayer for bail and submitted that there are evidence on record that the petitioner is having extramarital relationship with the co-accused, which is the motive behind the commission of crime. And there are also call detail reports collected by the IO during course of investigation, which would show that the petitioner had kept contact with the appellant. Considering the submission made by the Learned Counsel for the respective parties, absence of any direct evidence, the nature of circumstantial evidence available against the petitioner, the fact that she is a lady and was on bail during trial, and there is no allegation of misutilization of liberty by her while on bail, and absence of any chance of early hearing, we are inclined to release the petitioner on bail. So this bail is allowed, and stay realization of fine. And Ejuta Chi Raut for it after summer vacation. Yes, next.
Item 15.
Custody.
Last date the custody certificate.
କେତେ ବର୍ଷ ଅଛି? दिटा नवा 15 16 है ना ऊपर की देता था हाँ पूछ रहे 16 के काउंसिल किए
I am on BC, my lord. I have already supplied flag E, my lord. Deposition copy.
केबे ଦେଇଛନ୍ତି
My lord, flag E.
फ्लैग फ्लैग
My
ये
lord,
दे नहीं
the
आमो पे
17th
दरकार नहीं आपण स्टेट काउंसिल को देई ना दी आपण पे नहीं ट्रायल कोर्ट रिकॉर्ड अछि पेन ड्राइव रे नहीं जाउना हला we'll take up this matter next week we'll go through it and in Mr. Panda's case you have received the it will come tomorrow get ready huh
my lord, I have filed a IA for interim bail. The daughter of the petitioner is going to marry on 30th April, my lord.
अच्छा अच्छा all right 8 of लिखंतु IA number 11115025 there is an application for interim bail on the ground of
Daughter's marriage of the petitioner.
केबे केबे
30th April, Annexure 1.
तो instruction नहीं जंदी तो बाहागर 30 तारीख आउट आपण बुझी दियंतु ओ आईए रो कॉपी देना दे आईए रो आईए रो कॉपी से मैरिज इनविटेशन कार्ड देले सिना से इंस्ट्रक्शन नेबे
Tomorrow, my lord.
आईए टा कॉपी दे देबे ने से कौन करी
Tomorrow,
लेखन let a copy of the interim application you furnish it during course of the day
my lord.
Along with the marriage invitation card which is annexed to annexure 1 to the land council for the state during course of the day we will obtain instruction hala put up this matter day after tomorrow hala 24 तारीख हाँ कारण 30 तारीख बागोर छुट्टी अछि ते 24 4 2025